yesterday it was listed. The division bench matter is coming up after 10 days, my lord. So can this be listed after 3 weeks, my lord?
Mr. B. Pathak, the counsel for the petitioner submits that the issue connected in the writ petition, which is, what is the issue?
Compulsory retirement in the sum.
Compulsory retirement in the sum rifles. Is also pending in the matter before a division bench of this court. We therefore submits the matter be listed after
3 weeks.
3 weeks. Right, now list after 3 weeks.
May I please my lord, I beg to mention item number 11 and 12, my lord. My lord, both matters are similar issue, my lord, regarding promotion, my lord. Because the promotion of the petitioner has been kept under cell cover due to pendency of a criminal case. So now, my lord, subsequent developments are there, and we have filed another petition also. And in that petition, we have been advised to approach the criminal court to get a clarification regarding that criminal case. So I pray that these two matters may also come after 4 weeks, adjourned for 4 weeks, my lord.
This has become infructuous now.
Not in exactly not infructuous, because the claim of the petitioner in this petition is there.
Still covered.
Yes, still covered, because on the date of the
Subsequent to that, you have approached the court says go and get a clarification from the criminal court.
yes, my lord.
So what remains here?
Because here also our prayer was there, madam, on the date of the DPC, no first thing was there, no.
Correct, but that nothing can happen unless the directions of the coordinate bench is complied with getting a clarification.
Yes, my lord. For that purpose, we have filed a IA in the criminal petition, my lord. So I pray for that this matter will be adjourned for 4 weeks. Let us obtain it.
There's nothing here. What is the point in adjourning? That's what I'm asking you.
But, my lord, because prayer is
There's nothing here. You already filed issue in the other writ petition, which has already been disposed of.
not because of
Pending, all right.
it is also
Pending, then that prayer he could have made it here also.
no, that time new charge sheet was not filed, my lord. That's why, my lord.
Now charge sheet file.
New fresh charge sheet has filed. Now issue is that, my lord, at the time of DPP, no charge sheet was there.
Ah,
Because charge sheet has been filed in the year 2022 and DPC was held in the year 2021 April, my lord.
all right. The request of Mr. D.P. Bora, matter stands adjourned for 2 weeks. Item 11-12.
Obliged, my lord.
Item number 18 million.
Yes.
Report number 12.
Item
18. Report number 12 million.
court number 12. Yes.
I pray it will be taken.
Item 18,
18.
court number 12, all right. Item 18.
I read to item number 26 of today news. Person citizens are engaged and make them possible for the day.
21,
26.
26.
26.
Why? What is the ground for adjournment? Personal living and law of councils. Learned council submits that arguing council has some difficulty in the matter, prays for the adjournment. Matter stays adjourned for 2 weeks.
May present. For the ministry for listing of the matter, as a pension matter. Otherwise, it was heard in there. It's only on the point whether the bar would come or not.
Fresh matter.
No, it's a continuing matter. Tomorrow, day after tomorrow, admission will be. Tomorrow, if we take a chance, because pretty long time, he's not getting any more.
Have it next week.
Some urgency is there. We try to write to the authorities also. In fact, there are orders to show that it has been filed its name also.
The agency, I understand. Have it on Monday. Coming Monday.
Or could we have on a Tuesday?
All right, Tuesday. If yes. Item 33 at the request of Mr. S. Thakur stands adjourned for 2 weeks, enabling him to file reply.
In item number 31, madam, I want to file activity to reply. The 3 weeks time will be.
MSS for same prayer. After 2 weeks.
Item
31.
Yes.
Consider declaration item number 21 of court number 12.
Yes.
Emergency in the matter, can it be taken up today? It's a motion.
21. All right.
May I please, Your Worship?
Yes,
I'd like to mention for listing of the matter, Your Worship, for orders, Your Worship. 2019 matter, Your Worship, and the matter pertains to wrong fixation of salary. Your Worship. Any date as part container of this for Your Worship.
give it. You take it from the court master.
My lord, may I bring for listing of a matter, it is a pending matter on Monday, my lord, if some emergency, some firecrackers were seized, my lord, but it is
What was seized?
firecrackers.
Ah,
They were seized in the month of September, my lord, since then they have been lying with the JMC, my lord, they are decaying,
is it relating to this bench?
bench 4, my lord.
So bench 4, you, Monday, you see, make a mention as bench 4. Not today. Today, if the matter is listed, you want to be taken up, I can take it up.
List for listing, my lord.
For listing on Monday, you make a mention before proper court.
May I please, Your Worship, with the consent of others, I will do next one attempt for 30 Your Worship.
3-0.
2 weeks time will be granted to file activity.
Item 30 at the request of MS
Take over, Your Worship.
J. Gogoi. Matter stands adjourned for 2 weeks, enabling her to file reply affidavit.
Yeah, please. I recommend item 43.
43.
Yes, sir.
Your name?
DG Google.
Mr. G. Gogoi, learned counsel for the petitioner submits that the order dated so and so, passed in WPC so and so has been complied. And therefore, he does not wish, the petitioner does not wish to press the contempt petition any further. Accordingly, contempt petition stands closed. Mr. P. Nayak appears for the respondent. So and so, give the item number 43. The matter contempt petition stands closed.
Yes, please, Your Worship. With the consent of others, sir, I beg to mention item number 32.
Yes,
Matter will be open
why?
for personal difficulty.
Oh,
Thank you.
who is the engaged counsel?
You the club.
Your name?
Be the club.
Mr. B. Top. For the petitioner, pays for accommodation for this week. Matter be listed next week. Item 32.
Your Worship, I'd like to mention item number 28 and 39. Your Worship, I would like to file implement petition.
Let the matter be called up. Wait,
May I please, item number 42, Worship. Matter has been complied, Worship. Matter has been complied, you can matter may be closed.
Mr.
ABT, Worship.
AVT Hawk, learned counsel for the petitioner, submits that the order dated so and so, passed in WPC so and so has since been complied with. Petitioner does not wish to press the contempt petition any further. Particular contempt petition stands closed.
Worship, I beg to mention item number 25, matter from honorable court number 12, my.
Yes,
We have been taken upon Friday, my lord. The matter is to settlement of market.
item 25, we can take it up today. Friday, we don't do. If you want, we can take it up today,
Friday, my lord.
not Friday. No. I can take up urgent matters pertaining to court 12. But I can't fix it. Why should I fix it?
Yeah, please, Your Worship. My lord,
If it is urgent, do it today. It is listed. Why are you not doing it today?
actually, Mr. Team Moto appears and I have given a mail for video conferencing link. My lord. Is out of this was a medical emergency. My lord. If the link is provided, my lord, the matter can be taken up today. My lord.
See for today. Item 25 second up.
All right, please, Your Worship. My lord, this matter was listed on the 4th of February. My lord. And if you are from the opponent side, time was taken for 2 weeks. My lord. Because it is very urgent termination matter proceeding. My lord.
All right, list it for admissions.
No, for hearing.
For hearing, it can't be listed. It will come in the, it will come in the part 2 list. Which year?
My lord, it is 21.
21 will come for hearing matter, will come in part 2 list.
Because in part 1 in on February 4th, my lord.
May have been there. What is the urgency here?
My lord, actually, terminated from service, my lord. It is urgency.
You bring it for orders, we'll see.
All right.
Mention it for orders.
All right. Please, worship. Trying to listing of pending liquidation for admission, 2018 method.
Pertaining to what?
Admission according to
All right. Take it.
popular. Thank you. With regards to the item number 41, I would like to introduce.
41. Mr. P. Kakoti, Learned Counsel for the petitioner, submits that the order dated so passed in WPS so by this court has been complied with petitioner. He has instructions from the petitioner not to press the contempt petition any further. Contempt petition therefore stands closed.
Much okay.
Motion item 1.
Yes. The petitioner here. Which is included in the High Court for one individual having the select page. With the select page to my lord. And find page.
Select list for selection for what?
Oh my lord, in difference, it is a staff selection commission has posted an advertisement for appointment in the CRPF. There is some rules, etc. There is advertisement dated my lord.
You belong to which category? General,
SC category.
SC.
SC category. The my lord, advertisement was 21/7/2008 and in this case, my lord, main position is that he has secured a mark, my lord, in overhead higher than the general category. The mark of general category, he had secured higher. But nonetheless of this position, he was not, his name was not included in the select list. In this case, my lord, another set of petitioners have approached the Supreme Court by WBC on 1681/2021. And in this case, by this Supreme Court has allowed their petition and directed the respondent to accommodate their position in the civil. Madam, the order has not been that I have come to know.
You take an order, show it to us.
Yes, order was my lord,
You show it to us, take a printout. Take a printout, we'll take it up at 2 o'clock, you show it to us.
Similar meter,
You have,
Yeah.
okay.
here he is FC, but this order they are OBC, but shares.
You are saying that
Yes.
this petition can be disposed of, yes.
Second last, second case order.
What is the previous decision of this court? Oh, 3764.
Many matter lordship. This one, there are many similar cases, they are followed the same.
All right, start then disposed of. What is the direction? What is the final penultimate direction?
To consider, to appoint him in any vacant post in any CRF, because from that selection process, there is no vacancy. Was already filled up.
Right, heard learned counsels for the parties. This petition has been filed with the petitioner. Challenging the seeking a direction to the respondents to appoint him in the post of constable within bracket GT in the Central Armed Police Forces in NIA, SSF and rifleman GD in Assam Rifles. So petitioner belongs to the SC category. And he appeared in the examination and was duly selected. However, he appeared in the examination and fared well. However, his name did not figure in the select list. Yes. Being aggrieved, he is approached his court praying for the direction to the respondents to bring out a fresh select list showing the name of the petitioner and to pass necessary orders for recruiting him to the post supply. Learned counsel appearing for the respondent submits that similar petitions has been disposed of by coordinate pages. Stop a copy of one such petition, a copy of one such order. Pass in copy of one such order dated 2/6/2023, passed in 3/169 of 2023. Has been placed before this court. Whereas learned counsel from the parties have been heard. Pleadings have been perused. Stop the order dated 2/6/2023 has also been carefully perused. Stop in the said order. Besides the orders passed by Delhi High Court as well as Tripura High Court. For my reference is made to the order dated 11/8/2022, passed in WPC 3764 of 2021 by coordinate bench of this court. So, a result of that order reveals that the issues involved in the same writ petition and the present writ petition are similar. And the coordinate bench has already issued directions disposing of the said writ petition, directing the respondent authorities to consider the case of the petitioner and appoint him in any of the posts available, vacant posts available. Stop. Since there is no dispute at the bar and the learned counsel for the respondent has fairly submitted that the case of the petitioner will be covered by the orders passed by coordinate benches for one. This court is of the view that this writ petition can also be closed with similar directions. Accordingly, taking note of the submissions made by the learned counsels as well as the directions passed in the order dated 11/8/2022 in WPC 3764 of 2021, the red week. The order dated 2/6/2023 passed in WPC 3169 of 2023. This writ petition stands disposed of by directing the respondents to issue orders of appointments, appointing the petitioner as Constable Chidi in any of the divisions of Central Armed Police Forces or any other armed police force as expeditiously as possible, preferably within a period of 6 months from the date of receipt of a certified copy of this order. In terms of the above observation, the writ petition stands closed.
Item number 2.
Who's for the petitioner? Who's for the respondent? PWD. There is some service pool required to be constructed. Notice. We thought we could close it, giving you a direction to construct the paper book. The service book. Because a learned amicus curiae was appointed and she is not appeared.
I will take note of page 17. Page 17 of the writ petition.
Yes.
This is a letter from the chief engineer PWD building to the executive engineer. They are of the direction with reference to the requested to reconstruct service group of
Petitioner based on the basis of the proper document then fix up the document. So my lord, there is already no doubt on this, I'll dispose of the matter.
No, we can dispose of provided you get some instructions and tell us what the executive engineer has done in respect of this. You can just get the instructions because this is an official letter. Still to find out what is the status.
Maybe because already there is contact at website.
Maybe. So we can post it on 9th of August. 9th of August. This is Guwahati division only. You just have to find out as to what progress has been made in terms of this can be obtained from the office of the chief engineer building.
I will fix up there, third level.
No, 10th is okay, 9, you want to know 10th. All right, 10. Fixing on 10th. None appears for the Leonard Amicus Curie is not present today. Nevertheless, this court has requested the learned government advocate, Mr. Thor, who has entered appearance on behalf of the PWD department, to obtain instructions on the status of reconstruction of the service book of the petitioner in terms of the communication dated 31 July 2012 issued by the chief engineer of the PWD building to the executive engineer PWD Guwahati building division 1. Stop copy of this letter is available in the writ petition at page 17. Stop Mr. Hall submits that he will obtain the instructions and he will attempt to obtain the instructions and place it before the court on the next week fix. Let the matter be fixed again on 10th of August. Stop. Copy of this order be marked to the office of Mr. Hall. To enable him to obtain the required instructions as directed. Based on Thursday.
Item 3 to 6.
Before appropriate bench, why is it before this court? Not partnered. These are not partnered matters.
Not partnered and notice also not reflected.
It's not partnered. They go before the appropriate bench. At relevant point in time, perhaps this bench was taking up criminal matters, so it's not partnered. To be listed before appropriate bench. As per Luster. Since these are not partnered matters.
For admission, item number 7.
Interim item number 4. Item number.
Interim order passed in WPC so and so will continue till the next date of district. Criminal case.
The petitioner before the lordship who applied for the post of part-time sweepers in Allahabad. My lord, we are coming to page 12. This is the advertisement for filling up of part-time, full-time sweepers in Allahabad Bank. This is the advertisement.
Yes.
Lordship will find the mode of selection. Selection was to be done through interview. And these are the branches where there existed vacancies. Now, this advertisement was issued on 30/11/2014. All letters were issued, interviews were held, and the petitioners who participated in the selection process were expecting the result. but no result was declared. And they have come before this honorable court for a direction that the results may be declared. At that stage, my lord, the respondent bank filed an affidavit taking the stand that Government of India, Minister of Finance has issued one circular which said that the government has taken a policy with continuing interview in the selection process of grade 3 and grade 4 employees of Indian banks.
Because of the merger.
No,
Then
it is a policy taken on, my lord, that policy your lordship may have a look at. It is a policy which your lordship will find at page 7 of the affidavit in opposition of the bank.
yes,
Now, may I read, my lord? This is Government of India, Minister of Finance.
no, subsequently, there was some association had given them the liberty to, the government had given them the liberty to apply for if they disagree with the policy.
No, ma'am.
Yeah.
Now, on this policy, this writ petition was disposed of by this honorable court. By an order by directing the bank to just inform them about the status of their application. After review filed by this writ petitioner, that order was recalled and the matter has been directed to be reviewed. Now, lordship, for a moment, have a look at the circular. May I read, my lord? It is, date is very important, my lord. It is 22/12/2015. And the advertisement is of 30/11/2014. I am directed to refer to the announcement made by the Honorable PM in his address to the nation on the occasion of Independence Day on the subject cited above, and to say that the Committee of Secretaries chaired by the Cabinet Secretary in his meeting held on 13/11/2015 has recommended discontinuation of interviews in the recruitment process in public sector banks for junior level posts by the deadline of 31/12/2015. Now, my lord, this circular says that the process of selecting people by interview should be discontinued by 31/12/2015. Now, the bank has taken a stand that in view of this circular, they have kept that selection process in abeyance, suppressing the fact that the interviews were already held before the issuance of this circular. This point was brought into the notice of the honorable court in the review application. And on being satisfied that the stand of the bank is not correct in view of these materials, the earlier order was recalled. Now the question before a lordship is, the bank has issued an advertisement on 30/11/2014, saying the process of selection will be by way of interview. Interviews were held. After the completion of the interview, when the results were supposed to be declared, this circular came. Now they are taking the plea that on view of this circular, they have kept the process of the selection again. Now the question of law, which requires a consideration by your lordship, the interview was the process at that time. The guidelines of the service policy, selection policy was interview. Whether this policy will have retrospective effect. Because this policy at the first time, it clearly says that the process of selection by way of interview should be discontinued latest by 31/12/2015. That means my understanding is after 31/12/2015, there should not be any recruitment process by way of selection. So if anything happened prior to the issuance of this circular or up to 31/12/2015, this guideline cannot have any effect. Now, my lord, I'd like to just put the decision on the point that first of all, any amendment in rules will always be prospective, unless the rules or the amendment specifically provide that it will be effective retrospective. And my lord, this is a selection process initiated in terms of a particular selection procedure. Since this circular has not
given any indication that it will operate retrospectively, then this circular cannot be the reason for not declaring the result. And if it is the case of the bank that they have not abandoned the process, they have not cancelled the recruitment process, they have taken a stand specifically, may I take a lordship to that particular stand. Page number 3 of their affidavit, paragraph number 9.
Yes.
In reference to the statement made in paragraph 6 of the writ petition, the deponent denied the statement as made therein and further begs to state here that due to instructions received from the Government of India, Ministry of Finance, Department of Financial Service, all the recruitment process of full-time part-time sweeper was kept in abeyance till further instruction. Now, my lord, they have kept the process in abeyance on the basis of this circular, which on the face of it clearly shows that we will not have any retrospective. So if the decision of the bank to keep in abeyance the selection process on the basis of this circular, which has no effect, then it is an irrational decision, my lord.
Yes.
Oh, before my friends said, my lord, just two things, judgment, my lord, for your lordship consideration. Lordship may take 1993 SSC 157.
Yes.
Lordship may come to paragraph 11. May read, madam. There is yet another aspect of the question where advertisement is issued inviting applications for direct recruitment to category of post, and the advertisement expressly states that the selection shall be made in accordance with the existing rules or government order. And if it further indicates the extent of reservation in favor of various categories, the selection of candidate in such a case must be made in accordance with the then existing rules and the government orders. Candidates who apply and undergo written or viability tests acquire vested right of being considered for selection in accordance with the terms and conditions contained in the advertisement, unless the advertisement itself indicates a contrary intention. Generally, a candidate is very important, my lord. Generally, a candidate has a right to be considered in accordance with the terms and conditions set out in the advertisement, as his right crystallizes on the date of publication of the advertisement. However, he has no absolute right in the matter. So, my lord, he doesn't have a right of appointment, but he has a right of fair consideration. So, my lord, if the recruitment rules are amended retrospectively during the pendency of selection, in that event, selection must be held in accordance with the amended rules. Now, my lord, here is a case where the recruitment rules were not amended retrospectively. The indication is very clear that the process of interview should be discontinued by 31/12/2015. And on that day, interviews were already over in all the branches, except in 2 branches where no applications were received during the last date of submission of form. We'd like to make it clear that now, my lord, may I skip few lines, then
Yes.
they say we would like to make it clear that a candidate on making application for a post pursuant to an advertisement does not acquire any vested right of selection, but he is eligible. But if he is eligible and otherwise qualified in accordance with the relevant rules and the terms contained in the advertisement, he does acquire a vested right of being considered for selection in accordance with the rules as they existed on the date of advertisement. So here it is a case where the petitioners were eligible as per the advertisement. The advertisement specifically provided that the mode of selection will be interview. Interviews were held. And when the results were to be declared, this circular came and the bank has taken a plea that in view of this circular, they have kept the process in. Okay.
My lord, bank has also suppressed the fact that the interviews were held by the time this circular was issued, which was pointed out in the review petition, my lord. And in the review petition, they had taken a stand that no, in some branches interviews were held, in some branches interviews were not held. Then also we find our affidavits pointing out the details of the date of interviews in all the branches, except in 2 branches where interview could not be held because no candidate applied within the last date of submission of application. So the prayer before the petitioner before a lordship is seeking a direction to the bank to just declare the result. We are not seeking a direction for our appointment. Whoever will be selected will be appointed. But since they have a
Yes,
and there are other 2 decisions, my lord, is of our division bench. GLT 2003, GLT 276, paragraph 2 and 5, my lord. Here also, my lord, the amendments of rules, if the rules are not amended retrospectively, then it will always be prospective. And if it is a prospective amendment, then the vacancies or the recruitment, the post will be governed by the pre-amended rules.
that perhaps is not a very strict regime today. There are subsequent judgments to that effect. But your case is not about rules, your
No.
case is about the advertisement.
Yes,
So
advertisement.
the advertisement was issued, the advertisement indicated the eligibility criteria, you fulfill, interviews held, results not declared.
But this
On the ground.
aspect is pending before the constitutional bench, that whether the amendment.
Maybe, but
Or another thing, my lord, there is also a question that this is not a case of changing the rule of the game during the pendency of the case. Because if your lordship takes into account, the game was already over.
your case is simple, that advertisement you appeared, selected, but the results were not
Not
declared.
selected,
Results were not declared.
not declared, and they cannot take the plea of this circular to keep the process in advance, because this circular does not apply retrospective, and by that time, the
And the third judgment,
third judgment, my lord,
retrospective.
retrospective. Paragraph number, the third judgment of 1991 SSC 411. Paragraph number 4. The sole question for consideration is as to whether the amendment made in the rules of on 14 May 87 rendered the selection illegal. Admittedly, the amending rules do not contain any provision enforcing the amended rules with retrospective. So, my lord, it is also my understanding that if the amendment does not indicate any retrospective application, then it is always prospective. In the absence of any express provision contained in the amending rules, it must be held to be prospective in nature. The rules which are prospective in nature cannot take away or impair the right of candidates holding diploma in mechanical engineering on the day of making appointment, as well as on the date of scrutiny of commission where they were qualified for selection and nothing appointment.
What do the rules say? Are there any set of rules here?
They do not, I do not know whether they have any rules or not, but
Why are you urging the rules?
just to give an indication that if rules operate like this, then these are executive instructions.
Therefore, what are the rules? What do
If
the
they
rules
don't,
say?
I do not have any idea whether they have any recruitment rules for the sweepers.
You have
They
it,
are, they don't have any rules.
Your Lordship, this is not a case where we have made some amendment. It is a case where we have kept in against the process
why?
due to the notifications and
The notification doesn't say, really, it is from a particular date.
your
Your process of interview selection was over well before.
2 places were pending at that particular point of time.
Hmm.
Because we have not received the list of the the list of the no nil statement from the employment exchange that needs to be provided to us. That is in case of Tarabai.
Once you have already proceeded with the selection process, why is this question of waiting for a nil
No,
list?
Your Lordship, I am saying that. That is, Your Lordship, that is number 12
Oh, page 12
of the red petition.
okay.
There are altogether 19 places.
Yes.
And out of that 19 places, serial number 2 and serial number 14 was pending
Hmm.
on the day.
Hmm.
And accordingly, the process was not completed. And in the meantime, we have received one notification, that is at page number 43. But since all the PhD has decided, accordingly, we have to go with that. Your Lordship, page number 43, that is of my affidavit.
No, we want to know that this is an advertisement floated by the bank. For what purpose? For recruitment.
Horrible.
So, do you want these people or you don't want the people?
Your Lordship, because of the,
Do you want this, do you want the services of the people for the posts which are advertised or not?
to that extent, I have to take them.
What instructions? Do you want it or not? You have floated an advertisement.
Definitely, Your Lordship.
When was the advertisement floated?
2014.
Then,
This was 2014. Your Lordship.
it's 9 years. Who's manning this post today? Who are in this post today?
But we do not have any details of that.
Temporary, there is always temporary people. They are temporary, they are carrying out the work with these temporary people.
Then why are you playing with their lives?
And by this time, all the petitioners
are
are
not playing your.
Of course you are. Your advertisement is there. You are referring to a particular policy decision. Only on the ground that the manning post in 2 places could not be completed.
And there was a discontinuation notification.
No, the discontinuation notification came much later. It came in 2016.
15,
It is came in
2011 to 2015.
And you completed the process when?
All the interviews were not,
The last interview was held in the month of September, Your Lordship.
2015.
Then
The last interview was
even with the circular, there is no power for you to declare the select list, even after the circular has come in place, because you have completed the proceedings well before the circular was issued.
But Your Lordship, does it make any indivisible right on the repeat?
No, there is a right for them to know whether they are selected or not.
Yes, that is what we have kept in abeyance.
Why?
That is because of this discontinuation.
Discontinuation starts from the end of the year.
Yes.
You completed well before the year. You completed well before the year.
No, Your Lordship, in the year of 2015, that is 11/9/2015 is the last. One interview has been held, except the 2 places. And thereafter, on 13/11/2015, there was a decision, and that notification was issued on 22nd of December. And the last page of my affidavit, Your Lordship.
The policy will apply with effect. Where is the policy? Let us see. Where is the policy decision again?
That is page number 7 of the affidavit of the bank.
That is the Ministry of Finance letter.
Yes. That is the foundation.
Thereafter, page number 45, Your Lord.
45.
Which letter? This is 7, 8, 9 of the letter. Take a. That is 12 February 2016.
There are also the deadline of 31st/12/2015. Has to be discontinued by 31st/12. That is,
In that, Your Lordship, with the first paragraph, last 3 lines. That if required, the PSB may explore other alternative to strengthen the written examination, such as by including psychometric test etc. to replace the interview mechanism.
You're reading from which page?
The page 45.
No, let's come to page 7.
Page number,
7.
yes, sir. Here also it is in the last 3 line, your worship. That is if required PSPs. There is a public sector bank.
Where is there at page 45?
The letter which is referring lordship we get at page number 9 of the affidavit, perhaps yes. Annexure 3 is the letter of 12th February 2016.
Which is the matter was deliberated in the managing committee meeting of IBA.
First paragraph.
Held on 29/1/2016.
Where is the order for review? Review order by which?
Perhaps the review order was passed on. My lord, the order of review was passed on 10/4/2023. Perhaps that review order is there in the file. I'm
Not
checking.
there. Can you file it?
10/4/2023. And the earlier order was passed disposing of the application.
3/6.
Yes, 3/6/2022. And that 3/6/2022 order was recalled by an order of 10/4/2022.
The review order is not available.
I checked, perhaps it is there in the second file. Okay.
Yeah. Yes.
Your worship, that in the repetition, we have been directed that to take the appropriate decisions. And it cannot be act as a promissory estoppel on us, because your lordship, that the advertisement cannot be.
Don't throw high sounding words where not necessary. You have floated an advertisement, you have to take it to the logical conclusion.
Yes, your
You have not taken a decision that you are abandoning the process. Why not? Take a
because the
decision
quality of the matter has been kept in abeyance by the ministry.
since 2015.
Yes, your lordship.
Right?
At that time, the process of was keep continuing. At that time, it was not stopped.
Do you have necessity of these people or not? In the branches?
I have to ask for your lordship.
You can't. That is why I was asking you to go through the letter again. Where is the letter of the ministry?
Yes, your lordship. Page number 7 of my affidavit. Running page is 44. 43 or.
See, you have been asked to discontinue. Why have you kept in abeyance?
Yes, your lordship. There is a line that if required, that is the last 3 lines from the middle. If required, PSB may explore other alternatives to strengthen the written examination, such as by including psychometric tests to replace the interview mechanism. And the second line, accordingly, it is decided to advise all the PSB to take necessary action with the approval of their respective boards, if necessary, to discontinue interview in the recruitment process for the clerical and subclerical post of the public sector bank by 30.
You are reading from which page? You are reading from which page?
That is your number 9, page number 9. No, page number 7. There, hold on.
Page number 7, we don't have that line you have read.
Your lordship,
It stops.
annexure A,
Annexure,
running page 43.
no, page number 7 is running page 42.
Okay. And why we have kept in abeyance, that is at page number 9.
Can you keep in abeyance for eternity?
Your lordship, the
Does it
decision-
require any instructions?
Till date, the decision has not been given to us.
Who is supposed to give you that instruction?
That is the ministry, your lordship.
In your bank?
It is
Are
the
the
board.
banks run by your board or by the ministry?
It is by the board.
It is by the board. So you are telling me that the board can't take a decision on this issue.
Your lordship, the.
You want us to pass an order that the board is incompetent to take a decision on a trivial matter?
Your lordship, may kindly come to page number 9, your lordship.
Yes.
The matter was deliberated in the managing committee meeting of IBA
Held on.
held on 29/1/2016.
Yes.
The committee resolved that the matter is to be taken up by the IBA with the Government of India Ministry of Finance, with the request to examine the issue of its entirety and allow the bank to continue interview for selection of the clerical staff. Also, accordingly, the IBA took up the matter with.
Mr. Council, we are competent to read. We have the basic qualification to read English. We can read it.
The questions.
No, we are reading it. We are asking you a question, you are making us read a letter. Question is, from 2016, the board is incapable of taking a decision. You are putting it on the shoulders of the ministry.
Your lordship, once the letter has been sent to the ministry via IBA, we have to be.
We'll record it in the order. And we'll mark a copy to the ministry. You are playing with the lives of people. Who is supposed to give you instruction there? From where will you get your instructions?
It's from the regional office and the.
You call your officers. You call your officers, let us find out. From 2016, you have not got any instructions. What is this? What do you think the courts are?
Your Lordship, the decision of the writ petition earlier that,
What decision?
that is, that the court.
You are interested to proceed with an interview. That is why I said, come and read page number 7. What is the import of page number 7? What does it say? What do you understand by it? We want to know, what do you understand by it?
Your Lordship, basically the motive behind this letter is only that the ministry wants to discontinue the process of interview.
And
And instead of that, they want to implement the mechanism of examination.
what have you done from 2015? What have you done from 2015?
Thereafter, we have written one letter to the IBA and that was pending.
So does it mean that you are absolved from complying with this instruction from the ministry? Does it mean for 8 years, you will keep on sitting on this matter? Your officers are playing with the lives of the people. You are unable to assist the court, so we are bound to call for your officers.
No, Your Lordship.
You are not assisting the court. You are a lawyer, you are an officer of the court. You are not an employee of the bank. Are you an employee of the bank?
No, Your Lordship.
Then
I'm not.
you are appearing before the court. You are skirting the questions of the court by making the court read irrelevant papers. We are asking you a simple question. What decision have you taken? Nothing.
Your Lordship, we have not taken the.
Why not?
Because the-
Why not?
After passing.
Has the ministry prevented you from taking a decision?
No,
Since you have not understood, we are constrained to call for your officers. Who is the officer in charge here?
it's very funny for Your Lordship, but. Very, very funny.
Who is your officer in charge here? We'd like to know what decisions have they taken.
Your Lordship,
Chief General Manager,
decision has not been taken.
we know decision has not been taken. The question is, why has it not been taken
Yes, Your Lordship.
by the bank?
I am explaining Your Lordship, that after passing of an order in the review petition, there was a review petition and accordingly we have not taken any decision.
Is there a bar under the review order not to take a decision? Is there a stay order here not to take a decision?
Because of the pendency of the review, it is pending because of that.
We are giving you one final opportunity. Get your instructions, clear instructions, failing which we are summoning your officers. When can you get it? 9th, Wednesday. There's a calendar just on the podium for your convenience. Ninth, Get on 9th. No 9th, let it be on 9th.
On 9th, I even out of station.
Then you send your officers. We'll talk to them. This is not the way to conduct yourself, Mr. Sharma.
Only one day.
This is not done. Don't skirt questions of the court like this. Heard Mr. S. Chakraborty, London Council for the petition, Mr. Sharma for the M. Sharma for the respondent. Which bank is it?
Indian Bank now.
Indian Bank.
Earlier it was Allahabad.
Within bracket erstwhile, Allahabad Bank. Mr. Sharma, after hearing the matter for some time, Mr. Sharma submits that Mr. Sharma is directed to obtain instructions in this from the bank authorities as to the status of the interviews conducted and the decision, if any, taken by the bank in respect of the process of interview. In respect of the process of selection an appointment pursuant to advertisement dated
30/11/2014.
30/11/2014, which was issued by the bank. Allahabad Bank within bracket AZ10 was for appointment, selection and appointment to the post of. Where is the advertisement?
My lord, page number 12. Part-time and full-time sweepers.
What are the posts?
Post of full-time sweep, part-time sweeper on up and 3/4 of scale of wage. That means given the full-time, part-time sweeper on half of and 3/4 scale of wage.
Full-time / part-time
Part-time.
sweeper on half and 3/4
Of scale of
Scale.
wage.
scale of wages for various categories under the several branches of the bank as shown in the advertisement. Mr. Sharma submits that we on the next date fixed, we will obtain the required instructions list again on 11th August. Partner? No partner. Why partner?
Item number 8,
We have not even heard. We have asking you to get the instructions. Let him get the instructions. Yes.
Under the application as the printed under the terms articles, the until agreement rules 1990. My lord, denied. My lord, we miss it. Our name is Mother and Boss this. So my lord, we miss this case. It already, it's not very important.
PWD doesn't require names to be reflected. You are everywhere. You must be everywhere.
That is the problem, my lord. I think we are everywhere, my lord.
The PWD department doesn't require the names to be reflected.
I know, my lord, but I don't have a file, my lord. Whether.
All right.
I have to from the- No, actually, it is fine, my lord. I have to see what happened. my lord.
I don't think you'll be able to file affidavit, but since your name is not reflected, you don't have the brief, we are accommodating you, but we want you to get instructions. You see, what has happened is they were appointed under the Assam Public Service Preferential Appointment. They are relatives of martyrs. Now, under the same rules, they are required to be given regular appointments, but they were instead appointed as work charge. The question is, why were they appointed as work charge if they were appointed under these rules? That's the only instructions you will get. Our learned counsel for the parties, Mr. R. Roll, learned counsel representing the PWD submits that he be permitted to obtain required instructions in the matter. He be permitted a short date to obtain required instruction in the matter. Accordingly, this is a matter after 2 weeks. Enabling the learned standing council PWD to obtain instructions list on 22nd August. Registry to reflect the names of standing council PWD.
item number 9,
If the existing council unit is feeling of blood, therefore can be under ways.
What is the matter?
So it's I'm with the engaged council.
You are not the youngest council. But you had appeared earlier.
No,
Your name is there. No?
no, sir, my name is not here.
Okay. Learned council, it is submitted at the bar that the engaged council, Mr. Lincoln Nair, senior advocate, is indisposed.
I'm appearing for. Page. Not page,
I'm sorry. You are appearing for respondents.
page, the phone number,
APDCA,
no, age is there.
AGCA. This is for AGCA or for all? Or you are for the private respondents. All readings are completed? Yes,
I have instructed to take internment for 2 weeks because he is not feeling well.
well, who is not feeling well or both are not feeling well?
The senior English
Who is the senior English
you
teacher?
can have.
Why did you mention? You mentioned? No. Oh, I'm sorry, I thought you mentioned. Learned counsel, Mr. M. Polita submits that the arguing counsel, Mr. UK Nair is indisposed, therefore seeks adjournment for 2 weeks. Mr. Kotoki, learned counsel appears for respondent number 3, 4, and 5. Mr. Chakraborty for 6. List after 2 weeks.
Item 10,
Yes,
Council for the petition.
non-appeal, but what is this is
They are seeking appointment without any basis. That is, yes.
there is a statement that some other writ petition was pending.
Yes.
It
That this
is still pending.
is one of them,
Three-
the
39
3900/2007.
still pending.
Fine.
We will connect it with.
Yes.
None appears for the petitioner involved. None has appeared for the petitioner on 9/12/2022 also. However, on perusal of the pleadings, it is seen that there is a statement that a similar
I am for the response.
that an issue, that the issue, similar issues are raised in other connected writ petitions and they are still pending disposal. Stop. One of the writ petitions where similar issues have been raised is WPC 3900/2017. Mr. D. Goswami, London Edition, legally appearing for the respondent, Water Resources Department, assisted by Mr. So-and-so, London Council, submits, does not dispute the averment made in the writ petition that similar writ
We are
petitions are.
for all the response.
Yes. Accordingly, for the interest of justice, let this writ petition be listed along with WBC 3900/2017 and such other connected writ petitions. Stop. List accordingly. We are directing listing of writ petition.
And I am appearing for all the response.
Yes, Mr. So-and-so appears for all the responses.
item number 13,
Petitioner to Roshi, personal process initiated by the Staff Selection Commission, applied for appointment, in the post of constable, LB. Lordship may kindly pass over the matter with airport or based on late enforcement. After some time.
You call her, let us see. Yes,
Lordship, yeah, actually, 1 page 12 is my application.
no, you appeared, but you were not selected.
I'm not selected. Lordship.
Why?
Lordship, Lordship will give the page 22, Lordship, action 9. Page 22. I've downloaded the result, Lordship. I was shown medically unfit. Down below, DME unfit. Otherwise, lordship will find lordship in the PT.
Why were you declared unfit?
Lordship, what happened, what I was submitting, I was declared fit. From the epidemic filed by the respondent, it will appear that I was declared fit. What happened, lordship, there's a reason, lordship, I want to show you a page, annexure 1 page 12. lordship.
So you marked yourself, there was something wrong with the gender.
Yes. What happened, lordship, I applied as female and
You applied as male.
no, election 1 page 12. Election 1 page 12.
Yes,
Serial number 6, lordship, title side, lordship. Gender,
yes, female.
female. That is my application law.
Hmm.
File online. And while issuing admit card, I was shown as male. Lordship, election 2, page 13.
Okay,
Lordship,
then I think some order was passed saying that in
lordship,
your application, you had given the gender as male
lordship.
and therefore it could not be corrected.
Lordship, I made before the authority by page 14, lordship, for correction of my admit card. And at page 16, lordship, will find that with reference to your representation dated page 15, lordship, then the last mail issued to me.
Mhm.
With reference to your representation dated 1st of July 19, I am directed to inform you that at this stage, this office cannot make corrections or modify any data, hence your case was forwarded to SSC headquarters in Delhi. After checking the database table and log.
You're reading from page number
Page 15, lordship,
15,
1 5 lordship, of my report.
which is an email dated 26 July.
Yes, yes, sir.
Okay. Yes.
And in the affidavit file, lordship.
Hmm. So what is the purport of this email?
So, what happened is, this email came up after my representation before the authority for correction of my gender status. As in the admit card, it was shown as my gender status shown as male. I wrote to the authority for correction of my gender.
What is the reply?
That is the reply I made. At this stage, it cannot be corrected.
Where is it stated?
Lordship, page, it starts from page 14, lordship. Page 14 of the election, page 14, 144. This is an email communication.
Lecture 14 of.
Page 14, election fee. Page 14, 1 petition, repeated.
Yes.
This is an email communication, lordship. First, I wrote, lordship. I am Sapna Peko with registration number, road number, constable general duty. Admit is incorrect gender. In admit can become male, please change from male to female. That I wrote, lordship. Then reply came, lordship. Please can copy of our application form registration for admit card. Then, lordship, I also wrote, lordship, with due respect, I wanted to state that my admit card issues and my examination will be held on 15th of this month. But till now, gender status didn't pay. According to your instruction, I sent the necessary document which you mentioned, but till now, gender status didn't pay. Below, I have attached my admit card. Kindly look forward to it and please revert me and do the needful as early as possible. It will be highly obliged to you. Then page 50. With reference to your representation dated such as that, I am directed to inform you that at this stage, this office cannot make correction or modify any data. Hence, your case was forwarded to SSC headquarters in Delhi. After checking the database table and logged by headquarters, they have intimated that there is no change in data.
Hmm.
And in the meantime, I participated in the selection process. I was declared fit in my physical case and I received the admit card for my medical examination.
Hmm.
Lordship will find, lordship, page 16 is my admit card. Gender status is male, and after that I participated in the physical case, lordship. At election 5, page 17.
Hmm.
Here, lordship, I have written as female on the top, lordship. Sapna, the roll number, Sapna Peko, female.
This is filled up by whom? By you?
Yes, lordship, signed by them, lordship.
Uh,
From lordship signatures, I suppose it was filled up by the petitioner. And the last year, lordship, qualified, page 18. And signed by all the authorities below. Three authorities were there.
hmm,
After that, lordship, annexure sheet, page 19, lordship.
Hmm.
I was called for medical examination.
hmm,
The address, examination center, lordship will find that AR Dimapur, Assam Rifles, Composite Hospitals, Purkomi, Dimapur, Nagaland. What happened here, lordship? I went to this place. And there, the petitioner found that that hospital was made for only for the male candidate. No female candidates were called in that station. So after school has been made, I was sent to another center at Sonitpur, Lokra, where I was medically examined.
yes, then,
After examination of what I submit, I was declared fit and my photographs were taken with a slate in front of me, written as fit. And I was expecting good result, lordship, by page 22, annexure 9, it was shown that I am medically unfit.
hmm,
And the contention of the respondent that I applied as male from the record also that I applied as female. And regarding my fitness, on their affidavit they stated I was declared fit in medical.
hmm,
Lordship, for a moment may take up as an affidavit in operation filed by the respondent.
yes,
Lordship may go to page 12, paragraph 15. Of the affidavit of operation. Page 12, paragraph 15. That with regard to the abandoned main paragraph 4 of the petition, the answering deponent humbly submits that the representation for change correction of the gender status from male to female was received from the petitioner by the male defense officer. The matter was referred to SSC headquarters along with a copy of the petitioner's application form, wherein the gender was indicated as female by email defense officer. SSC headquarters, after due scrutiny, informed that there was no change in data, meaning thereby the gender that appeared in the admit card is the same as captured in the application and is being stored in the commission database. Now, the response received by the SSC headquarters was conveyed to the petitioner by mail letter submitter. Therefore, it is clear that the candidate had filled her gender in the online application form as male is the female. This is their case. And from their record, I am going to show before lordship that this statement is not correct. Lordship may go to page 50 and actually one of them. Affidavit of operation.
yes,
This is their intersect communication document. May I read lordship? This is mail communication. With reference to your right letter number subject charge dated 24/7/19, I am directed to inform you that this office received more than 600 representations from candidates regarding discrepancies in photos, signatures, gender, domicile address, and not satisfied with normalization mark. Some female candidates qualified in male list due to error made by the candidate in their online application form. And some candidates did not enclose the application form as they do not have application form with them. The following female candidate has filled correctly as female in the online application form, but she has qualified in PST, PhD, and the male category of it. Below is my name. Meaning thereby, I have applied in due manner as female. The following female candidates have filled correctly as female.
yes,
And lordship, one more paragraph lordship, page 12 again lordship, page 12, paragraph number 16. Yes, with regard to the statement made in paragraph 5, 6, and 7 of the repetition, the answering deponent responded state that the PET, PST, and DME was conducted by Assam Rifles in accordance with para 1 and 2 of recruitment notice. As per the report received from the concerned CACF Assam Rifles, the petitioner was declared fit in both PT, PST and DA. So, Your Worship, I was declared fit in DA also, and I applied to due manner as given.
Yes,
Person, we have said that everything in the word together. Kindly having to the case number 12 of our LPG, paragraph 17.
70.
That we regard to the statement made in paragraph number 8, 9 and 10 of the petition, the answer in deponent takes to state that it is required that the vendor of the petitioner is recorded as male in the candidate data available at the commission. The data of all the candidates are automatically populated and stored by the system from
No
the
system, whose system? Which system?
computer.
Who, under, it is under which department?
The staff selection commission.
Commission. And who has given this letter? Page 15, email. Staff selection. So kindly see the last line above the chart, above the table,
Yes, sir.
which he has filled it correctly. So there is a contradiction within the staff selection. Then if she has filled up correctly, then she should not be penalized for that, for some mistake which may have occurred. Then how can this statement at page 17, para 17 be done in view of page number 15? The gentleman who has filed this affidavit is the same gentleman who has issued that letter.
Yes.
Then, why is he making contradictory statements? Is the deputy secretary, the affidavit is filed with the deputy secretary. Then, your affidavit, please explain. It's your affidavit.
Yes.
What do we understand? Do we rely on para 17 or we rely on page number 15?
On the basis of his representation, his letter, which is election 1, is sent to the higher authority. SSC and here. On the basis of his representation, this letter is sent to the higher authority to check about this error.
Where is that online form? Is it available?
Is not available in passport.
Is it available where?
Application, it is annexed in his.
That online must be available in some data.
Yes, it must.
Where is it? You get a copy of that online?
Yes.
No, I am asking you, what is the meaning of this letter at page 15? Is it a letter by the deputy secretary to the confidential so and so?
On the basis of the representation, is it from the.
Meaning that the petitioner has requested for the following information. Is that what the deputy secretary is asking? Or the deputy secretary is replying saying that her name appears correctly?
On the basis of his representation, he make an inquiry for.
The confidential department.
Yes.
And what is the reply there to?
Then after that reply is not
annex here, Lordship.
Do you have a copy?
I have to take you.
You get a copy of that reply. And if possible, get a copy of the online form which is filled up, that will fix the issue. From where will you get it?
On last occasion, I am directed to for this record also, but they don't directly give me this instruction. It is they told that it is difficult to send the computer in computer is done. It is stored in computer. I will check and try to take the reply of this letter.
You ask your client. We are not asking him to get the bunch of reports. If your officer is capable of showing us in court through a laptop the online form of the petitioner, that will take care.
Yes.
If he is unable to do it, if there is a difficulty, then ask him to certify a printout which is taken from the online. And he must certify that this is a printout which has come out from the online. And a reply to this letter at page 15. Page 15 is the email. You must have received some reply. That reply is not here.
That reply is not enough.
Yes, Mr. Chakraborty, let him get the information.
Only, may I say, along with the record, even taken place of the case Lordship, regarding fitness in the medical Lordship, that record may be of the consult. Because here in the evidence, they said, I am medically fit.
I heard Mr. S. Chakraborty, learned counsel for the petitioner, MS. Borwa, learned CGC. CGC appearing for the respondents. The petitioner before this court appeared for the recruitment process of Constable GD in Central Armed Police Forces like NIA, SSF and Rifleman GD in the Assam Rifles. Examination 2018. According to the petitioner, the candidate filled up all the required details on the online form and reflected her gender as female in quotes. However, the admit card which was received by her reflected her gender to be male within quotes. This was brought to the notice of the respondent authorities. In the meantime, the petitioner was allowed to participate in the selection process, a recruitment process. The petitioner appeared for written test. There is no written test, no interview.
PPL, PPST.
Appeared in the
Physical standard test.
physical
Standard test and physical efficiency test.
physical standard test, PST, and physical efficiency test, PET, and was declared to be medically fit. However, subsequently, she was informed that she was not selected as she was declared to be medically unfit. Being agreed, the petitioner is before this court. Para MSS Borwa, learned counsel to the CGC appearing to the state, submits that the affidavit on behalf of the department has already been filed. Para, upon perusal of the takings on record, to see that in the affidavit filed by the department, an email dated 26th of July 2019 addressed by the Deputy Secretary is enclosed where it is stated that the female candidate, namely the petitioner, had correctly filled her online application form showing her gender status as within bracket female. However, an averment contrary to the said email is made at para 17 of the affidavit. In view of such contradiction, learned CGC is permitted to obtain instructions seeking clarification from the authorities concerned as to whether the petitioner had correctly filled out her status as her gender status as female in the online application, and also as to whether she was declared medically fit in the BST and BET tests held by the respondents. Full stop. MS Borwal and CGC submits that should be permitted 2 weeks time to obtain the specific instructions. So that view of the matter, in view of the prayers made, let the matter be listed after 2 weeks and bring back to obtain the specific instructions as directed above. Please again after 2 weeks, give a date.
Not in PhD, he is qualified in PhD and PhD in respect of medical.
In the medical, last line, rather than PhD, strike it and say whether she is qualified medically, whether she was declared medically fit in the medical test. Yes, after 2 weeks.
25 over. Item number 14.
Against the background of the matter regarding the labor conducted in the FCI. There are 4 categories of labor. One is PLC, that is
You do, see, Mr. Singh, you do whatever you want to do. We are only on the findings of the committee that death had occurred due to the accident. Because he fell down.
that is not a denied.
So in that view of the matter, you take your decisions as per the provisions of law.
The husband of the petitioner was under the DL system. Now, as per the 2000 circular, it has been declared as a child carer, and as such, it has been phased out.
When did the accident take place?
In the year 2012, madam. And it was considered in the year 2015 also, madam, only some persons were appointed under the compassionate appointment. Her serial number was at page at serial number 47, madam, at page 14 of my division opposition. So only 5% was of the labor were appointed minorities. Her position could not serve my.
Page number?
Page number start from page number 13 of my division opposition, madam. This is the senior list for the appointment and professional ground. Page 40. Her name appears at page, serial number 47. Lal H. Balchan Ram. Would I not hold for 2000? Very good.
Here, what happens, they will, on 28/11/2012. And they submitted report in 2019, they took 17.
But it was under donor consideration, madam.
How can it be?
Because
How
the
can it be?
seniority list.
No, not seniority list.
I will
You had already taken a view that the death did not occur to the accident. He subsequently went out of the hospital. Then he was not feeling well. Then he got admitted and died.
But
That was your finding earlier.
then her candidature was considered, madam.
So it could not have been considered.
And people also promised me, I will take her also to base 58 and then I checked in. That is their communication. It say from assistant general manager,
Page 28.
page 28. I must have tell you. My assistant general manager, the assistant general manager, it says, in reference to the subject I did, it is statement that even data taken, while for today, they want to attach for compassionate ground appointment involved. They work for this by application dated 31/1/2018.
further subsequently by letter number 12, so. 26, 2019 district office. Guwahati has forwarded an application of Sri Rajkumar Bharti, son of Srimati Sheila Devi for compensation of town appointment along with no objection of Srimati Sheila Devi. It is therefore requested that the application of Rajkumar Bharti for compensation of town appointment against State Balchan Ram may be considered instead of Srimati Sheila Devi. This is for information and necessary action. This is their official publication. So my limited prayer is that whether you are not in the context, order for appointment of this son. Of the, during the time of accident, money you were the minor. Now it is 23 years. So mother surrendered for her gave my daughter and paid for appointment of this son.
May I submit my lord? Last conditional appointment was made in year 2015. So thereafter the conditional.
What is the scheme now? What happens when an employee dies today? What scheme is available?
They are under the zone of consideration on conditional appointment. But here is the case, the petitioner belongs to the DLC, which has been declared as a dying.
Is that, are there nobody appointed under the, are there no employees? No employees,
Nobody is appointed.
any residual employees today under DLC?
There might be still working under DLC, but they are being phased out.
No, phased out.
And no direct appointment has been given.
Correct, you don't give direct appointment, you work out a scheme.
I have stated the instruction that the petitioners has already been placed under the roster of the appointment on the compulsory ground to the applicant of the work. Still they are. Our candidature is still under consideration. If any appointment is being made on the compulsory ground, our candidature will be taken.
You just made a mention that DLC, they are phased out, they are not eligible, that is what you said.
That is with regard to the DLC matter. If that can be considered in other department.
Of course, it has to be. On what basis you are saying that?
My lord, I have a one last. After I have, that's point number 2, right? Well, from 2015 onwards, the last week was considered for a constitutional appointment. Thereafter, rules of appointment has been made under the constitutional grounds.
When is it, when are they likely to be considered? What is the vacancy position?
You can see as such, no, there is no direct recruitment of the labor man. They are inducted from the contract labor man.
We are going by your instruction, we are going by your instructions. Your instructions say that they are placed in a roster for appointment.
They are
on
on
compassionate
roster
ground.
for appointment, on the list of the compassionate appointment.
Yes, appointment
Future,
for what?
Future, if it is made.
Appointment for what?
Appointment under the, for the labor man.
Labor. Now, are you saying that this list is a list which will continue in eternity?
It is their money, as per my.
What is their position? When are they likely
When the next appointment will be made.
What is their position? What is their position in that list?
And as per the 2015 mallet, her name appeared in the.
This is a letter of August, 1st August 2023.
Yes, mallet.
So as on 1st of August, what is their position?
My position is that.
Their position in the list. Seniority.
Let me take the seniority. It's fine.
You take it. Find out.
Oh, I think it's fine.
Is there a compassionate scheme available?
Compensation scheme is there, mallet. There is a circular also. 2000.
Is it available here?
It is not available here.
Mr. Watts, what is that? What's it?
The state of certain appointment and compensation terms will be made available on the regular basis and that too on the regular vacancy mean for that purpose or available.
Page number? I think you should call your officers. There'll be more clarity in the instructions.
I will bring the clarity.
No, you call them.
I will actually tell you that.
You call your officers, let us hear it
I
from them.
will myself for serving.
As they say, we'll hear it from the horse's mouth. Call them.
On written note, I will take on on this Friday.
See, they're coming with piecemeal instructions. First, they're saying it is not a death. It is not a death in service, it's not a case of dying in service.
Still says under the zone of consideration.
What is the meaning of zone of consideration? What is the meaning of zone of consideration?
Consideration means that whenever this vacancy arises.
I can understand your department not willing to explain to the petitioner, at least to the court, be fair and tell us what is the meaning of zone of consideration. When will the zone be, when will they ever be included from the zone of consideration to the zone of being appointed effectively? Which post?
The position was there after 2015, no such appointment was. made.
Then why do you say zone of consideration? What is the meaning of zone of consideration?
Whenever the next appointment will
When?
be. That is
From
there
2015,
there
from
is there was
2015 till date, for 8 years, not a single appointment has been made.
After 2015, there was no.
Why? Has there been no
Because
deaths?
in Level category, there no appointment has been made.
Why?
Because they are not direct.
Is the scheme not in place?
They are inducted from the contract labor sale, PPS or DLC, but DLC now it has been closed from 2020 onwards.
I did you say they are not eligible for compassionate appointment because they belong to X category, Y category?
I will bring specific mallet on.
Or you say that, yes, they are eligible, their cases will be considered.
On Friday, I will.
We are giving you time till Monday, saying it.
I don't know Tuesday. Tuesday.
Then we are having it tomorrow.
Or
Have it on Monday. We are having it on Monday.
there is one outline. In outline.
You send your colleague. We are asking for instructions, therefore we make it convenient. You go to outlying benches, you send your officers to court, we'll deal with them.
Madam, can you take it on Friday, madam? I can bring it.
Yes.
If it is not
Madam.
convenient, we are not.
All right, bring it on Wednesday. Wednesday? 9th of August. Mr. B. Singh, Learned Counsel for the FCI, submits that, BK Singh submits that he would like a short date to complete his instructions in respect of the steps taken by the FCI towards the prayer for consideration of the case of the petitioner for compassionate appointment under the scheme applicable in the FCI. He submits that the matter be listed again on 9th, by which date he will obtain the required instructions. Learned Counsel, MSA Bhattacharya, appearing for the petitioner, does not object to the prayer made, list accordingly on 9th, enabling Mr. Singh to obtain required instructions.
Item 16.
In this case, for a reputation was allowed, but subsequently my learned friend filed reputation. And review was put to dismiss, and because before probably Indian gets the workshop was also there. And there are terminal methods demanded back.
What is the order passed?
Order matter, under earlier disposal of matter, on matter, 21/8/2022 matter. First direction was there because matter, in the rule of game was sent, because for advertisement, there was no restriction regarding their action. Subsequently, after selecting the petition of matter, as a first nominee on merit, is 59%. Then, private restaurant has been selected in place of petitioner. In the on the ground of there was restriction was there scheduled caste committee, but that clause was not against the violation of the guideline also. That's why it was repetition was allowed. In paragraph, it's specifically mentioned in earlier judgment, and findings in paragraph 13.
But I think it is better since I was on the bench before the DB.
My lord, honorable chief justice has my lord addressed speak for my lord.
Correct, but this matter was interfered with by a division bench where I was a member.
My lord, accept your lordship. Other than your lordship.
Yes. For any of the bench without you.
In spite of this order, in spite of this order also, they are continuing their service, more than 1 year.
Before any of the bench.
My lord, he has no.
List on Friday.
Because my lord,
List on Friday. Before
Yes,
any of the
right.
bench without you.
he has no custody.
Friday.
Item number 17.
In this case, my lord, the petitioner before the lordship was allowed to undergo my lord veterinary field assistant training in the year 1996. And after a long wait, my lord, he was just appointed in the year 2019, my lord, to the post of veterinary field assistant. Unfortunately, my lord, this man, my lord, died thereafter, my lord, appointed on my lord page 12, my lord, on 16/5/2019, my lord, and died, my lord, on 21/5/2019. Accordingly, my lord, as per my lord policy, he is entitled, my lord, he is family person. But as per rule, my lord, there is a condition, my lord, that 1 year is not completed. Therefore, my lord, we have taken this page 25 notification, my lord. It says, my lord, the ground is that, my lord. In the, my lord, compassionate appointment, my lord, there was no condition there, my lord. The regular employee have to, my lord, complete 1 year of service to avail, my lord, compassionate appointment by the family.
Where is that? Is it mentioned in the circular?
Yes, sir. It is page 25, my lord, under second, my lord, and the relevant portion, page 26, my lord. There is an embargo, my lord, page 26. Second paragraph, my lord. However, government servant must complete minimum 1 year of continuous service without pay before that while in service.
You are challenging this.
Yes, sir. But lordship, can you look page 25, my lord, is the very outset, my lord, it is mentioned, my lord, this scheme is taken, my lord, in view of compassionate appointment. But in the compassionate appointment, my lord, circular, I have also connect for ready reference, my lord. There is no this 1 year, my lord. It is a very rare case, my lord.
Okay, so far as compassionate appointment is concerned, that is just an exception of rule entirely on the 57 police chapter also. But this is also it comes from the civil law. That 1 year requirement is the rule 1 copy of the pension. But anyway, in this case, also my affidavit is pending, bias and putting the instruction of the law. Not in the meantime. I
Only, my lord,
Animal husbandry has filed it. You have filed.
and notification was issued by the current.
Yes. Let their affidavit be on record because you are challenging that notification. Mr. P. Nayak, Learned Standing Council Finance, praised for was granted 2 weeks time to file the affidavits on behalf of the finance department.
actually, my lord, not take, I think, they have 1 year also taken time.
Mr. A.M. Bormian does not object. You don't object,
Yeah, I have objection, but my lord.
does not object to the prayer wait for 2 weeks. Placed accordingly after 2 weeks. MS Emily Photo appears for veterinary department. Anyone else? You are appearing to see as Hazarika for personal department. List after 2 weeks.
Item 18.
Yes, please.
Hello, here I am.
Your readings are complete. This is a case for dismissal. Right. At the request of NSA Gayon CGC, matter stands adjourned for the week. Mr. Learned counsel for the petition does not object to the prayer made. After a week, give a date.
14.
It will be after 14 minutes, 17.
21, 21.
And then I have to get 70.
Not possible.
Then,
16th.
yes, sir.
Right.
Item 19.
Material rocket. In this matter, the petitioner conducted advertisement for appointment Anganwadi worker. They appeared for the interview and selection was also made. The selection was selection was then sent to the director for approval, and approval was accordingly according. Thereafter, the citizen set up the matter without complying with the direction of the director. So we approached the Honorable Court. And Lordship kindly have order dated 14/9/2021 in this matter.
Yes, what are these?
All of them are there.
Appointed. You have seen.
No, as regards petitioner number 1, I know, madam, that she was appointed by the.
You have not given a copy.
Just had only one copy. I proposed that.
Give it to him. Let him be satisfied. Mr. D. Bora, learned government advocate, appearing for the petitioner, submits that all the 4 petitioners have been appointed. As Anganwadi. As what?
Anganwadi worker.
Anganwadi worker.
And Anganwadi worker in the same center, different centers.
No, different centers. They are both.
The respective centers. Stop. Mr. M.A. Chaudhary, learned counsel for the petitioner, submits that since the petitioners have, since the learned government advocate has submitted and produced copies of appointment letters for all petitioners, no further cause remains in the present writ petition. In view of such statements made by the councils, the writ petition stands dismissed as not pressed. Interim order, if any, stands vacated. Copies of the appointment orders are kept in the case report.
Disposed of matter.
Disposed of already.
Item number 20.
During this method, the petitioners are the faculty of one Woodcraft Institute. They are the professors and lecturers and non-teaching staff also, your lordship. They were appointed, your lordship, in 2016, and during their appointment, your lordship.
We were directed to file an affidavit, lodged. I have a copy of the affidavit which I provided in the course of reading.
Mr. A. Chaliha, learned standing counsel, finance department, undertakes
I'm serving a copy right now.
to file an affidavit during the course of the week on behalf of the finance department. Finance department.
Yes, Lord.
He therefore prays accommodation for the week. Mr. M.H. Doskor, learned counsel, does not object to the prayer made. Let the affidavit be filed, registry to trace the, connect the affidavits. Which will be filed by the, upon such filing of the affidavit, registry will connect the same with the case reference. This is the matter on 21st August.
21. Item number 21.
None appears for the parties on call. You're appearing? MSS Burwal and Gogoi appears for respondents. 1, 2, and 3. None appears for the petitioner on call. Please. Next week.
22,
Yes. Affidavit file, not file. Not file. Why? You have been given 4 weeks in 2021. What are you doing? You don't want to file? MS S. Mushari, learned counsel appearing for the bank. Praise for further time to file the affidavit in opposition on behalf of the bank. Mr. Alam T. Sheikh, learned counsel for the petitioner submits that in spite of opportunities being granted, affidavit has not been filed. Purely for the ends of justice, the prayer made by the learned counsel for the bank is allowed, permitting her to file the affidavit within a period of 3 weeks from today. This after 3 weeks.
23,
So in this, petitioner wait for benefit under the own pension scheme. He was appointed as a driver under the DRDO, DRDA, that is already abolished during 2016. Now, thereafter, through an notification, all the employees of DRDA, Kumaigaon and other DRDA were absorbed in Jila Parishad. And accordingly, he was also absorbed. Now, my grievance is that, since I had joined in the service in 1980, so why should I be why should I not be benefited by the old pension scheme?
You are regularized
I'm regularized.
from
I was
1980.
already regularized, in 19. Now, the similar set of, in a similar case, I have cited the judgment also, the annexure 5, page 38, in minor irrigation department. This honorable court has already granted similar prayer. And there's a batch of writ petition, there's a writ petition, they have similar employees of DRDA, 350 employees, they have already approached the honorable high court by WPC 5705 of 2020. And it was disposed of by directing them to file a representation. And I'm told that those writ petitioners have again approached this honorable court with a similar grievance, like this writ petition.
Then
That writ petition was not being able to locate.
you refer to the judgment which you have relied on.
That page 38.
What is the direction given?
The last 70 page 49, para 17.
Yes.
So they are yet to file affidavit. Whichever is the last one, 2021.
Have you gone through this judgment of the coordinate bench, please?
I think it should be coming to it, and they will file it.
No,
Yes, affidavit,
in view of the judgment, no affidavit is necessary.
Yes,
In view of this judgment, no affidavit is necessary.
but you also will have to distinguish the fact from metric.
Do it, we are ready to hear you.
And the another matter is the pending or
No, maybe, but whatever is pending, but this judgment has decided an issue.
No, our problem is that that was listed, last listed in 2021. So that's it. They are not listed, you know, some more time maybe even to ask for filing affidavit.
We're waiting for your affidavit, since long. They are not eager to file an
Now you are now blaming the court.
As a studying council, I have been appointed to the last year.
You are blaming the court.
In my tenure, we have not made it.
You are now blaming the court.
No. This is my personal.
All right, at the request of Mr. K. Paul, Leonard additional AG, might stand agent for 2 weeks, enabling him to complete his instructions. As it is submitted that the matter was last listed in the year 2021. It is further submitted that there are other petitions pending, details of which may be necessary to be referred to during the course of the hearing. Mr. R. Chakraborty, learned counsel, the petitioner submits that the matter be listed for hearing on a short date. Stop accordingly. This after 3 weeks. Enabling the learned additional AG to complete his instructions and file necessary affidavit if so advised. Placed on 29th of August. All right. Mr. P. Nayak for Finance Department. Mr. Sharma.
Item 24.
I think we also otherwise the buildings are completed.
What is the matter?
Reading order, then you which the hearing order.
Hearing.
Because the expiry date of 25 and 2025.
What are you asking? What are your prayers?
Because my lord in 2021, 1920, it is just committed constitution, my lord, the identity card and everything was issued with the secretary was nominated, and that term is for 5 years. Our term would my lord go up to 25. In the meantime, the or the DPS has passed an order on 5/8/2021. They put it in another list. The interim order is there, man.
Interim order that you are to continue.
Our contention is that in our affidavit, we have specifically mentioned that there, the petitioner, except 2 petitioners, the others have completed 50 years. As because that is the
Age,
limit.
the age limit.
Shall not be less than 18 and shall not be more than 50. But on the date we are. When they were removed lordship at that time, the out of these 7 petitioners, 5 have completed 50. According to that. On the date of constitutional matter, we are reading the.
Affidavits are filed.
Yes. Yes, we have filed our affidavit. By reference number 4. That is only conclusion by the referee. Of this 8 lordship, 6 have completed.
Completed what? Completed what?
50 years. 50 years.
So if they are 50, beyond 50 they cannot.
Because of the interim order passed by the Honorable for 30 years.
Then why?
No, on the date of they consider the committee. We are within the 8. So term is for 5 years.
Or 50, whichever is earlier. Term is for 5 years
5 years.
or 50 years, whichever is earlier.
Let
You- you
let it be have around 8, I. Immediately, 8.
We don't need any hearing if you agree that we have crossed 50 years.
No, I let me take. So, I don't think how to make it there, everything I did.
Your clients feel that they are younger.
Hello?
Your clients feel that they are younger.
Village people are younger, man. After 80 also they will take different times. They are also knowing.
That joint request that the matter be listed after flux. Enabling the respective, enabling the council to the petitioner to complete their instructions.
I am private dispute about. Because there is another matter. Matter be.
You are appearing for which respondents? Mr. Your name?
And Ahmed on behalf of Mr. Anwar.
Mr. N. Ahmed appearing on behalf of Mr. N. Bora. Submits that he appears for respondent 6 to 13.
WBC number 2711-2020.
It is further submitted that another writ petition being WPC number 2711
11.
of 2020. Having similar issues is also presently pending, therefore both the matters must accordingly get this writ petition be listed along with WPC number 2711 of 2020.
Township is fixing a date.
And fix a date 28th of August, 28th.
Item 25,
If may continue to that.
Interim order, if any, will continue till 28th of August.
Otherwise. Petitioner is 4 employees also, he is working as a 4 employees in Borpala, PFC under the temporary. His prayer is to pay the minimum wages, he is only paid 3,000 and his another prayer is to regularize that. And I have also filed some presentation for the options.
So what is your prayers? To consider,
Consider.
where are you representing?
It has not been filed, and this matter is pending in 2021.
Yes, madam.
This prayer is also basic income care. As remuneration. And to report of representation submitted by the petitioner on 25 to 20.
We heard learned counsels for the parties. This writ petition has been filed by the petitioner. Praying for grant of minimum wages stop. Petitioner is working as grade 4 employee on honorary basis in Borpala Public Health Center under the Health Department in Kachar district. It is submitted that the petitioner is being paid.
Appointed by the hospital management society.
Hmm?
Appointed by the hospital management society.
It is submitted by the learned counsel for the petitioners that the petitioner was appointed by the Hospital Management Society and is presently rendering his services under the so-and-so PHC Kachar. Stop, he is being presently paid a fixed pay of these 3,000 per month. Stop. He is assigned duties to assist the field works in NPW and SW for vector-borne diseases along with COVID-19 staff.
The designation is 821 losses.
When was he appointed? When was he appointed?
2017.
17.
Since his date of appointment in the year 2017, petitioner has been rendering his services.
2170.
Is appointed on 2117. Stop. Learned counsel for the petitioner submits that besides his prayer for seeking regularization in the post in which he is working, petitioner is entitled to at least the minimum wages till his case is considered by the Department for Regularization. Also, learned counsel for the petitioner is referred to the judgment of the of this court, passed in between number 45 of 2014 in the bracket, Bendas and others, to submit that the petitioner is required to be granted the benefits as directed by the court in Upenda's stop. It is further submitted that the prayers made that his grievances were ventilated before whom? Where is the representation?
Yes, 28 to 41.
It represented before the
Deputy Commissioner.
Deputy Commissioner, Joint Director, Health Services, and Deputy Commissioner and Joint Director, Health Services by separate representations. So who is to decide? Who will dispose of?
Just because I can highlight that problem.
Before whom? The same representations that remain pending. Stop. MS Bora, Learned Standing Council Health Department submits that the petitioner is not entitled to regularization. However, his case for minimum wages, if any, can be considered by the department, subject to the petitioner satisfying the necessary requirements, satisfying the eligibility. So, having heard learned counsels parties, it is seen that in spite of opportunities granted, the response from the department has not yet been filed by the department. It is also seen that the representations filed by the petitioner have remained pending. So, taking note of the submissions made as well as pleadings and report, this court is of the view that the petition can be disposed of with a direction to the Director Health Service to Secretary Health.
Submitted before the hospital management society.
Minimum wages will pay. Will pay the minimum wages, Mr. Nayak. Whatever.
And secondary lawsuit, the appointment was only in the year 2017. And the federal judgment clearly states that at least in 10 years.
10 years.
You dispose it off. By whom? Director Health Service. Joint Director. Joint Director Health Service. The Joint Director Health Service will consider the representations filed by the petitioner and thereupon dispose of the said representations stated to be filed before the Joint Director by speaking order. Any such order that may be passed by the Joint Director, copy thereof shall be served on the petitioner. The Joint Director will dispose of the representation within a period of 60 days from the date of receipt of the certified copy of this order. The petitioner may file a copy of the petition along with a copy of the certified copy of the order before the Joint Director. Within 1 week from today. The petition disposed of in terms of the
Item number 27.
Mr. Nayak appears for Finance Department, MS D. Bora for response.
Thank you.
Thank you. Yes.
Maybe something related to promotion of master worker and payment of time pay. However, the petitioner is intending to file petition on additional affidavit regarding the promotion of master.
Master role workers.
Paid for,
Right.
they will regularize.
Mr. B. Forward learned counsel with the petitioner. Submits that you'd like to bring on record certain additional documents for proper. For proper disposal. Decision in the matter. He prays for 2 weeks time. Please accordingly. Prayer allow, please accordingly.
28.
That due to wrong. And the petitioner has filed another case also. Whether this case is for against the punishment for 5 written being later. And then he filed another petition also. Both the matter may be taken, let it come on coming future.
Councils at the bar submit that there is another writ petition filed by the same petitioner. Being WPC number
5308.
5308 of 2020.
21.
21. It is submitted that both the writ petitions be connected and be listed together after 1 week.
Next Tuesday,
Uh,
8th of August.
List accordingly on 8th, may be difficult, we can have it on 10th.
And then it is after 28 minutes.
After 28 to 0,
20 after any different, anything.
or like 22nd August. 22nd.
29.
Hmm? Yes, Mr. Dr.
On the basis of the disciplinary proceeding report, proceed with the matter. We will also look at the charges.
Then we'll fix it on a hearing. If the records are available,
It can be, I am getting.
you are sure that there is no factual dispute, because once we proceed to hear, then again an affidavit is necessary, matter gets deferred.
Sir, that is not a something what is available. The lawsuit can.
Noted. It is submitted by the learned counsel that the matter can be heard and disposed of on the basis of the records which are available. Matter pertains to dismissal from service of the husband of the petitioner. From which bank? Grameen Vikas. Some Grameen Vikas Bank. Stop. Accordingly, let the matter be listed on 10th of August. 10th.
Any date submitted to matter.
10th of August.
10th of August.
August. For this is called admissions. For admission. Admission hearing.
Bail hearing item number 34.
Yes. Charge sheet not filed.
Certificate has been filed, my lord.
Now,
Now, earlier certificate filed, my lord. After filing of the certificate, I filed in bail application. My lord, one of
you can request your colleague to inform you. We'll take it up in the second half. At 2. Yes.
Supplementary list for admission item 56.
Who is for the petition? This is for CAPF. None appears for the petition. We pass it over for the day. Mr. K. Gogoi appears for the respondents, passed over for the day. Mr. D. Bora for respondent 7, Mr. Gogoi for
1 to 6.
1 to 6.
For orders, item number 35.
None appears for the petitioner on call. Office note dated 24/07/2023. It reflects that steps on respondent 8 has not been taken despite the order of the Honorable Court dated 14/11/2022 and the order of the Law Zimmer Court dated 11/4/2023. That view of the matter, the petition dismissed for non-prosecution and for not taking steps. Interim order if any stand vacated.
Item number 36.
Maybe matter relating to promotion. I have already promoted from deputy director to joint director of planning and development department. Your lordship, a copy of notification. That will make I.
You are not pressing.
Now, already I have promoted.
All right. It is submitted by Mr. M. Talukdar that the grievance of the petitioner has been redressed by the respondent department. Petitioner has already been promoted to the what post?
Deputy director to joint director, planning and development department.
Has been promoted to the post of joint director, training and development. Copy of the said order,
Are available.
notification dated 17 June 2019. Issued by the secretary to the government of Assam Transformation and Development Department is furnished by the learned counsel for the petitioner is placed on the board. Mr. D. Vora appears for the respondents and does not and supports the statement made by the learned counsel for the petition. Oh, Mr. Sharma appears. H. Sharma. Accordingly, the petition stands dismissed as infructuous, interim order if any stands vacated.
Item number 37.
By read against the deficient particular deny also challenge in our education lordship. And last one.
None appears for the petitioner on call, Mr. K. Gogoi, learned counsel appearing for the respondents. You are appearing for respondents number,
Which I have all the respondents.
appearing for all the respondents submits that the order dated 22/06/2017 passed in WPC number 3794 of 2016, as well as the order dated 17/7/2017 passed in IACD 2227 of 2017 has since been complied with. What was the direction?
So I have got this is minus I. This is considered that okay. With the condition for it was rejected.
The Technical Education Department was directed to convene a review selection committee and consider the case of the petitioner for promotion to the post of lecturer in Chemical Engineering Department lying vacant in the Assam Engineering Institute at Guwahati. And the entire exercise was directed to be carried within a period of 60 days from the date of receipt of the certificate.
Because rejected due to the additional quality manages there.
Mr. Gogoi has submitted that the Departmental Promotional Committee by its meeting held on 30/17/2017. Has considered the case of the petitioner in terms of the directions of this court.
22/6/2017. Action of the Superintendent of Report.
In terms of the directions of this court. And the same committee held that the petitioner obtained BE second class in the year 2010. After amendment of the Assam Technical Education Service Rules 2008, and therefore the petitioner is not entitled to be considered for the post of appointment to the post of lecturer in the Chemical Engineering Department in the AEI. Also. Upon due perusal of the copy of the minutes presented in court, this court is that the direction of the court, the order, the judgment order dated 22/06/2017, last day, WPC 3794 of 2016, read with the order dated 17/7/2017, passed in ISA 2227 of 2017. It is seen that the direction of the court was to consider the case of the petitioner and stop. The same having been done, the directions contained in the orders have been complied with. It is submitted by the learned counsel for the petitioner that the say minus is also challenged. The minus is presently under challenge by the petitioner. That view of the matter. Its contemplation stands closed.
Kept the part of the report.
Disposed of. The copy of the minus furnished is kept in the part of the report. Is kept in the court record.
I'm very sorry, but I did not take that.
Not infractuous.
No, infractuous.
But you did not take steps.
Only any date, Mala.
You did not take steps.
Takes that.
Item
35.
all right, 35 earlier dismissal order. It is submitted by Mr. E. J. Soikia that the that the steps on respondent number 8. Respondent number 8 shall be taken within the course of 1 week from today. He prays for further time and submits that the matter be listed after 2 weeks. Alright, accordingly, prayer is allowed. Petitioner to take steps. Respondent number 8 by registered post ID within 1 week from today. List the matter after 2 weeks.
Item number 38.
Order complied. Has the order been complied with?
Any idea about getting this, I have not engaged for.
What ideas do you have? Share with us.
No, no, sir, I take to my implementation in this.
Implement. Your name? J. Polita, Mr. J. Polita, Learned Council Secretary. Submits that we'd like to file improvement petition for improvement of the present incumbents in the post of Director Secondary Education. In the post of the respondents shown in the content petition. He prays for 2 weeks further time. Prayer is allowed list after 2 weeks. Item number 39 also same prayer.
Item number 40.
This case, there is direct to file subsequent petition with payment done.
What petition?
Subsequent petition.
Substitution. Learned Council for the petitioner submits that you'd like to file substitution petition to bring on record the legal heirs of the petitioner. We therefore prays for 2 weeks time. They are allowed list after 2 weeks.
44.
Time may be granted for filing it.
Why you have not complied with the order? Order complied, not complied. You are appealing for who?
On behalf of Mr. J.
You get instructions by Friday. By Friday, whether the order dated 3007/2018 has been complied with or not. And if not complied, we intend to draw up contempt proceedings against the respondents.
But you will get the input.
Yes, list on Friday with the request of Mr.
He does. He does on behalf of J.
D. Das, appearing on behalf of Mr. J. Roy. List the matter on Friday.
45.
Debit service report. In respect of the newly implemented respondent list after 3 months.
46.
Yes,
Lordship, on the earlier occasion, the responding authorities were supposed to purchase whether the BPDPC would conduct.
yes,
Lord, document I have not received anything, but LUTPP has contacted and the petitioner has been promoted to the post of professor on 7/2/2022, my lord.
all right.
Lordship, in this-
And LUTPP was conducted in the year 2021.
Yes,
He has been promoted to the ultimate post after that or
what is the direction? Let us see the direction.
Lordship, when the petitioner approached the committee, she was not given any result regarding.
direction was, my lord.
Review DPC to take place when the petitioner is to be considered for promotion.
Yes,
The post of assistant professor.
But Lordship, we have not received any order regarding the promotion.
You get that order, Mr. Bora?
no, my lord, that order I have not received, my lord.
You ask for it, 2 o'clock, get it for us.
2 o'clock, my lord, it will not be possible. I have to go to the office because that review DPC proceeding I have fought for, my lord.
We don't need review DPC. If they have already been promoted,
Yes, my lord.
then why go for review DPC?
Yes, my lord.
That means-
After review deficit, he has been promoted.
So get the promotion order,
Yes, promotion order, I'm trying to.
get it,
Yes, madam.
promotion order to the post of assistant professor.
Now, that has been done long back. Now he has been promoted to the post of professor also, my lord. Assistant professor, then associate professor, now he has on 20. On 7/2/2022, he has been.
What are you saying, madam? You have not received this.
Petitioner had approached the,
When?
recently she had approached the committee. So she was
Now
not
he
given.
is in the post of professor, my lord, on 7/2/2022.
You can't be in the post of professor if you are not in the post of assistant professor.
Lordship in this.
Because after assistant professor, associate professor, then.
What is our post today?
Lordship must have.
I have got the.
But then, what her grievances was that even if she was promoted, it is not reflected 8.7.
In her salary?
But it will be definitely reflected, my lord, because.
Does she have a designation or not? She has a designation, she must be
She is an assistant professor right now.
right now.
Professor, my lord.
You get that order at 2 o'clock. You also get your instructions. At 2. Get special number 34. No, just 1 minute, Mr. Chaudhary. Yes, what happened?
And for the promotion order is there, my lord. Promotion order I have received, my lord. He was promoted on 23/2/2021. And then, my lord, the gradation list has also been prepared, my lord. The gradation list has also been prepared.
Is promoted and posted. Then, yes. That learned counsels for the parties. This contempt petition has been filed by the petitioner alleging willful deliberate disobedience of the directions contained in the order. Dated 7/6/2016. Passed in the BPC. Number 3892 of 2009 and other connected petitions. Stop. Mr. Bora, TP Bora, another counsel, appears on behalf of the respondents and submits that the order has been complied with. And thereafter, the petitioner has been further given a promotion to the post of Professor GTC Dibrugarh by orders dated 23rd of February 2021. Copy of this order has been furnished by Mr. Bora before this court. The submissions made by Mr. Bora are not disputed by the learned counsel for the petition. Accordingly, since the directions contained in the order were to constitute was to constitute a review BPC to consider the case of the petitioner for promotion to the post of assistant professor. One. Consequent to the directions issued from the review BPC was held from a petitioner was promoted to the post of associate professor and thereafter the Professor GTC Dibrugarh. In that view of the matter, the contempt petition stands closed. Notice is issued a recall. Copy of this order furnished before the court is kept in the case. Contempt petition stands closed in this post.
Item 34.
Yes.
May I please your lordship, my lord? Second time this bail application was filed, my lord. My lord, your lordship kindly come to the my lord order, my lord. I along with my lord. Case 30/28, my lord. I along with my lord 6 person have filed a bail application, my lord. Before this honorable court, my lord. And my bail application was rejected on the ground the page 32 by para 11, page 32. Considering the gravity of the offences as well as the severity of the punishment prescribed, if convicted and considering the master is still under the investigation, the charge sheet yet to be filed. This court opinion the release of the petitioner at this stage may hamper the progress of the investigation be carried out. The person alleged to be involved in offences, including the petitioner known to be informant and his family member, all of them reside the same area. Taking into account all this factor, this could give that therefore bail at this stage. The word at this stage, my lord, investigation will be have been rejected. Now, my lord, investigation part has been completed, my lord. Now, charge sheet has been filed. My name has been mentioned in the my lord, column of the charge sheet. In the content of the charge sheet, my lord, my name has not been mentioned. And I have go to the my lord 161 statement, my lord, morning, my lord. All of the kindly go to the death, my lord. Whether any material against me, my lord, not a single witness is set against me, my lord, subject to verification by the public prosecutor. Now he may ask a question, my lord, whether anticipatory bail can be filed after filing this article. I have a my lord, judgment of the effects of my lord.
No, we don't need a judgment.
Yes, sir.
We are
Yes, sir.
aware that it can be filed.
Yes, sir.
What we want to know ordinarily, it is not entertained because the matter is now before the trial court. So the trial court is in session of the matter, they know whether your presence is necessary or not. Or any custody, you are required to be retained in custody or not. These are issues to be taken up by the trial court
Yes, sir.
ordinarily. And there are judgments of the apex court that merely on appearance, you shall not be arrested unless. So can we not relegate you to the trial court to appear and file applications, and trial court will make an independent assessment whether your custody is necessary or not, and then relying on the law laid down by the apex court in Siddharth and other cases, we pass appropriate orders.
May I submit, my lord? One thing is that, my lord, why, my lord, this I want to show to the judgment of the apex court. Moment, my lord, your lordship has passed this order, my right under section 438 will exhausted, my lord. Because, my lord, learned trial court is the magistrate court, my lord. That should be committed to the session judge. The CJM.
Well, it is not yet committed.
Yes, no, not it. No, lordship. Once you kindly go to.
This is what 302, na? All right, then can we take it up tomorrow?
Yes, sir.
Have you gone through the reports?
I have gone to the records.
You point out the relevant portions tomorrow at 2.
Yes, sir.
We'll take it up tomorrow at 2.
Yes, sir.
The list tomorrow at 2 for orders.
Item number 47.
And also to the earlier order with the clear 2022 logic. And the honorable for directed to produce the report of law.
No inquiry was held.
Lordship, Agency is D. Upamanu is conducting the case, Lordship. Today he has some difficulty, Lordship. So he left about early. Let the matter fix another day, Lordship.
But you have not filed your affidavits.
That
Have you
is
filed?
not in my knowledge, Lordship. He has informed me, Lordship, that he has already given to the family department. So date may be given, Lordship.
It is submitted by MS D. Ora that Mr. Upamanu, what is this? D. Upamanu.
D. Upamanu.
Learned Council is conducting the matter for the health department, however, because of personal reasons, he is not available in court today. Therefore, it is submitted that the matter be taken up on some other date. let the matter be listed on Friday. Will it come on Friday?
Monday.
Monday or it will be on Monday. Miss, your name please? Ms. Wensu, Learned Council, petition. List on Monday.
Item number 48.
Eroded 50 kilometers per epsilon, the regulation is located as below the page 19. The page 19 of the petition, there are 16. Submitted in the petition and had Indian Mission already crossed the age of superannuation, therefore could consider the appropriate quantity as has been done by the coordinate bench and therefore direct lump sum payment of amount of fees, considered negligence, wage, considered justice for purpose. The petitioner has not attained the age of superannuation, he has around 9 years of service there. In the other piece,
Yes, what?
Yes. His date of birth is 1/2/1973 and date of retirement is.
So is there any objection to the? No objection. All right.
in the
You only want this part to be deleted.
some record knowledge and the similar case which Lordship had referred to, there was a reinstatement with notional benefit and continuity in service.
Yeah,
Reinstatement and the continuity in service is all the.
Then we'll have to hear it.
Yes, that I have obtaken, but in the that part I don't have any objection.
Lordship allows the review date, takes up the.
No, the review is only to the extent of correction that he is not superannuated.
Not only that, because the other part is also there. At page 8, my lord. Actually corrected and.
What was the direction in the other matter?
The other matter, the direction coming is read out and given a copy last time. Otherwise, the direction was. Moreover, the incident with passes of time has surely lost its relevance. Hence, I feel that ordering for Innova inquiry will not be justified. Accordingly, held that the disciplinary proceeding was initiated, respondents are required to reinstate the petitioner. He will be entitled to notional continuance of service and seniority will be protected. And then there was the issue of 2 lakhs of. Exactly the same department proceeding, same process, everything remained the same.
But here the fact is some defined he was in jail,
That is after I was dismissed, I came out, I went to jail, everything, I've been acquitted there.
No, your proceedings were initiated together, same persons, same allegation,
Yes.
same witnesses,
Yes.
same conclusions. So when one coordinate bench has passed an order in a particular manner, unless there is a reason to defer, we would not like to defer. Do you have an extra copy of the order?
So it is there in the A number 69 of 2021. At page number 57. At page number 57. Page 57. Page 57 from the bottom, 5th line. And Lordship's judgment at page 18, paragraph 14. The total concurrence.
Okay, but learned counsels for the parties, this review petition is directed against the judgment of an order dated 6/6/2023. Passed in WPC 4518 of 2008. The review petitioner was working as a CISF constable, or a constable in CISF at a relevant point in time when, because of an incident which occurred during his service tenure, disciplinary proceeding was initiated. Full stop. The inquiry was ordered by the respondent authority against the petitioner as well as a fellow constable. Stop. The disciplinary inquiry was initiated. Was separately initiated against both the constables. The disciplinary, the inquiry officer conducted the inquiry, submitted its report on 16/9/1996. With a copy being served upon the petition. On the basis of the report submitted by the inquiry officer, the disciplinary authority, namely the commandant, CISF unit Jorat, issued the impugned order dated 30/10/2016, whereby the petitioner was dismissed from service. Initially, the petitioner had approached the Allahabad High Court. However, the petition therein was dismissed by the Allahabad High Court on the ground of lack of territorial jurisdiction. And thereafter, the petitioners approached this court. A similar writ petition was also filed by the other constable against whom similar disciplinary inquiry was instituted in respect of the same incident, and against whom similar punishment, namely an order of dismissal from service, was issued. The same writ petition, the same delinquent employee also filed a writ petition, being WPC 4517 of 2008. This writ petition came to be dismissed. Sorry, same writ petition came to be heard and disposed of by judgment dated 10/5/2018, whereby the coordinate bench of this court had interfered with the orders passed by the inquiry officer as well as the consequential dismissal order. Stop. Against this order, a writ appeal, being writ appeal number 120 of 2019 was filed, and the writ appellate court by judgment and order dated 29/8/2019 dismissed the writ appeal and upheld the order passed by the learned single judge. Stop. No further appeal was carried to the apex court. Stop. During the course of the hearing of the writ petition of the writ petition in which the present review petition has been filed, it was submitted that at the relevant point in time, the writ petition being WPC 4518 of 2008 came to be dismissed for non-prosecution, and therefore the same could not be taken up together for hearing along with WPC 4517 of 2008. Stop. Upon hearing both counsels and upon due perusal of the material before the court, as well as the pleadings on record. This court by the judgment and order under review allowed the writ petition interfering with the impugned order, interfering with the order of dismissal. So this order was passed by recording a finding that the conclusions arrived at by the coordinate bench. That this court had agreed with the conclusions arrived at by the coordinate bench. Passed in WPC number 4517 of 2008, and that there were no grounds to differ with the conclusions arrived at by the coordinate bench. Stop. Better. In the same judgment, it came to be recorded that the petitioner had in the meanwhile crossed the age of superannuation. And consequently, the relief for the prayer for reinstatement and notional benefits as granted by the coordinate bench in WPC number 4517 of 2008 was not granted. Better. Learned counsel for the review petitioner submits that the finding of the court on the basis of submissions, but finding of the court was arrived at on the basis of submissions which was made, which is not supported by the records. Learned counsel for the petitioner submits that by oversight, it was submitted that the petitioner had crossed the age of superannuation when, as on date, he is about 53 years, and the age of superannuation under CIS is 60 years.
51.
As on date, 51 years. Better. Learned CGC appearing for the respondent, MS Gayan, does not dispute the fact that the judgment of the coordinate bench in 4517 of 2008 has attained finality. Full stop. It is also not in dispute that the incident in which the inquiry was initiated in respect of the present review petitioner, as well as the petitioner in WPC 4517 of 2008, are one and the same. Stop. The witnesses produced during the course of inquiry were one and the same, as also the documents relied upon. It is also not disputed by the learned counsel for the respondents that no appeal in the meantime has been preferred against the judgment and order presently under review. And in view of such circumstances, more particularly in view of the finding of this court, that the conclusions arrived at by the coordinate bench in WPC 4517 of 2008 have been concurred with by this court, and that there are no grounds to differ with the conclusions arrived at by the coordinate bench. This court is of the view that the judgment and order dated so and so needs to be reviewed insofar as the directions contained in para 16 of the judgment is concerned. Stop. In para 16 of the judgment and order dated 6/6/2023, it was ordered as under para 16 code. In view of the findings arrived by this court and in view of the discussions referred above, the para 16 of the judgments now stands recalled, and instead the following directions are issued. In view of the discussions held above, this court considers it appropriate to grant similar relief as has been done by the coordinate bench in WPC number 4517 of 2008. Stop. As such, the petitioner, as such, in view of the interference by this court of the inquiry report dated so and so, as well as the order of dismissal dated so and so passed by the disciplinary authority, the petitioner will be entitled to. We are not directing reinstatement, notional.
The reinstatement is to be there, therefore the predicate should be notional.
What will be his position today? Constable?
Every point of time, yes.
The petitioner is directed to be reinstated as constable CISF with immediate effect. And the service benefits applicable to the petitioner will be released by the authorities in as per provision of law. He will be given the notional benefit of his service and his seniority ought to be protected. Full stop. In view of the injustice found to have been caused to the petitioner, this court sustains the payment of a lump sum of ₹2 lakhs as back wages, which will be considered just and proper for the injuries suffered. Review petition, accordingly stands closed. This order shall be read with the judgment and order dated 6/6/2023 passed in WPC number so and so.
If you agree.
49 to 53.
Environment take method I. Different measures that of advertisement and legal appointment method. First method, I have been filed method during the relative method out of city.
You don't want their names, you want striking out,
Yes,
only striking out.
striking out of 6 petition or matter, but I have stated in there are 2 matter, page 22.
Which are the names you want to be struck off?
Yes, matter, and it's matter, there are 2. And serial number 3, Srimati Marina Brahma, serial number 20, Mona Lisa Basumatari, serial number 26, Chitralekha Bhurbayani, serial number 28, Yanaka Brahma, serial number 31.
Why do you want your names to be
Because
struck?
they got matter regular appointment manner, matter recently manner by.
I heard Mr. S. Chauhan, learned counsel for the petitioner, this happening. Anyone for the health? You're there for the health? No, this is Boroland.
Boroland.
Who is the Boroland council? Hmm? Who is there? Is she available in court? Please inform her. You are there?
Morning, matter.
You can appear, Mr. Rava.
So in the morning.
Are you also BTC council?
Yes.
We will record your name.
Yes.
Mr. S. Rava, learned counsel appearing for the. Have you got a copy of the IA? Please furnish a copy of the IA. He is appearing, he has to go through the copy. For the respondent, Boroland, BTC. Namely respondents 1, 2, 3, 4. Mr. C. Hazarika for respondent 5, MSD Bora for respondent 6. Stop. This IA has been filed by the petitioners. By 5 of the petitioners who had filed WPC number 3296 of 2018, along with other petitioners named therein. Stop. Learned counsel for the petitioners submits, applicant submits that the petitioner number, that the applicants, the present applicants are petitioner number 3, petitioner number 20, petitioner number 26, petitioner number 28, petitioner number 31, and 33 respectively. Stop. All these petitioners have in the meantime, during the pendency of the writ petition, being appointed, regularly appointed as ANM nurses under the BTC authority as such. Under Director of Health Services, Government of Assam. Stop. As such, they do not want to proceed with the present writ petition and therefore seeks orders of this court for striking of their names as writ petitioners from the area of writ petitioners. Stop. Mr. Learned counsels for the respondents do not object to the prayer made. Stop. In view of such submissions made by the learned counsel for the petitioner and not objected to by the learned counsels for the respondents, this court is of the view that the prayer made can be allowed without issuance of notice on the private respondents, as it will not adversely affect their interests. Stop. Accordingly, the names of the petitioners number 3, 20, 26, 28, 31, and 32 in WPC number 3296 of 2018 are hereby struck off from the area of petitioners. In view of this order, the registry is to reflect. You are for the petitioner. So in view of this order, the petitioner will now furnish amended course title and file it before the registry. You file an amended course title with the petitioners and file it before the registry within a period of this week. During the course of this week. Can you do it? Within a period of 1 week from today. The amended course title as may be filed with the petitioner will be reflected in the writ petition 3296 2018 by the registry. Stop. Copy of this order be also kept in the case record of WPC 3296 of 2018. I accordingly stands allowed and disposed of. Yes.
Main matter, the other is victim matter, disease matter. Desire matter, it's editor state matter. The matter, state matter, doctor.
But you'll have to file the amended course title for this.
Within 3 quarters matter time.
Let all the writ petitions be listed again after 1 week.
Yes.
Supplementary list for orders, item 57.
Yes, who's appearing for? Mr. B. Chaudhary was supposed to appear. Mr. B. Chaudhary, please call him. Passed over. Huh? What is it? But
Item number 18 of note number 12.
yes,
In this case, easy area is similar market, under this area. Last year also I only got A, and now I am in 8. And in this year, native was issued on 29th of May 2023. And I have recommended accept to this country. Then I obtained a copy of the NIP and fill out the formula. Then I went to doing the same formula, we put the video, some video. Then he did not accept the check. And because the subordinate police issued a notice, that is why I have an accept to is 23. On that ground, the video either pass any order or and on the similar point, I have another case in another case, another marketing lot, and the order will go to the state their order of the I have telling you the same.
I have it started. So far as this market is concerned, your authority has cancelled the inclusion of this market method, the cattle market, in view of the fact that there has been certain amendment.
there is a common tender issued,
Yes,
page number 12.
and the cancellation concerns this market, cattle market.
Where is that?
Where was the marketing lot? Is 15. That would be.
What is the name of the market?
There is serial number 7 without. Yeah, there's no 15 serial number 7 without. Katazar, Puramara, Hart.
This has been done in view of the amendment method of the Assam Cattle Preservation Amendment Act 2021. Section 3.
Where is the earlier letter of 12/10/2022? 12/10/2022. Okay,
It is annexed in the instruction. This FP thus brought to the notice of the authority. On that count, the market was not cancelled. Is after the amendment was brought into the notice of the authority.
this is for what market? Cattle market.
Yeah.
So it has been taken out of the tender process.
Yes,
Have you got a copy?
there has been a provision of
That I have.
We have an extra copy. You bring it on record if you want, Mr. Rossi. They have brought it out of the tender process.
it has been done in view of the amendment prohibiting cattle market along the international border.
It may come on Monday, so Friday, Monday, I take all this.
I heard learned counsels for the party. This petition has been filed by the petitioner. Agreed by the what is the order, annexure for order?
And then we will have And except for your page 23, within the order issued by the SP, who can sell all cattle market. Page 23.
9/6/2023 issued by the SP Boxa to the Principal Secretary BTC for cancellation of settlement of all markets, huts, parkings, park huts, ferries, etc. for relating to cattle as per section 3 within bracket Roman capital Roman 2 within bracket 3 of the Assam Cattle Preservation within bracket Amendment Act 2021. Stop. When the matter is called up, Mr. S.R. Rabha, learned studying council BTC, has produced a letter from the BTC Secretary, whereby it was informed that the BTC had cancelled the earlier letter issued for inclusion of the concerned market in question, namely Katajhar Koramara Weekly Open Market, including its cattle market. So, a copy of the communication has been produced before the court and is kept in the case report. There are Mr. Rossi, learned counsel to the petitioner submits that he be granted a week's time to complete his instructions in respect of these communication received in court. List on Monday. As per report. Yes.
Item number 21 of court number 12.
Yes, Mr. Chaudhary.
One of those cases that will stop your lordship's judicial concept. No, I am being for Asmana. But just so before I take your lordship to the papers, may I just briefly indicate what the case is? But your lordship is aware that MSME Act was brought in, enacted basically to promote the micro, small and medium scale industry. Under the act, there is a notification which exempts deposit of earnest money deposits by small scale industry. Now, my lord, there is a further notification of 2020 which says that if a small scale industry gets upgraded to medium scale, it will get the same benefit of exemption of depositing EMD for a period of 1 year. That has further been amended, making it 3 years now. Now, this is an NIT where these clauses have been incorporated in terms of the statutory provisions. And I am a industry which got upgraded from small to medium. And I am entitled to the benefit of small, of not having to deposit the earnest money. And that clause is also incorporated in the NIT. I submit, the only requirement is that I am required to submit both the certificates of being a small scale and having been upgraded to medium scale. Both the certificates I am required to submit. Both of which I have submitted, they form part of my tender. In spite of that, in a cryptic one-line order, they reject my tender. And now I have come to know, in the meantime, they have opened the financial bills. And I have come to know what my specific instruction is. My rate is 2 crores lower than the respondent number 4. May I straight away take your lordship to the document? Your lordship will first come to page 23.
Yes.
First 22 months. This is my small scale registration. And your lordship will kindly note the date. Towards the bottom, there's a date of filing. It's 1/5/2017.
Where is it indicated small scale?
It says enterprise type on the left side. And
B.
Enterprise type, right in the middle of that page, you'll have to find. First, date of commencement, then major activity, then enterprise type. Against that, you'll have to find small.
No, you're referring to page 22.
Page 22.
Okay, 22 is Udyog Aadhaar registration certificate.
Precisely. If your lordship comes a few lines below that,
Below that,
your lordship will find towards the left, first your lordship will find date of commencement,
enterprise type, P,
enterprise type, small.
small, okay.
Now, if your lordship kindly turns to the next page, this is my upgradation to medium.
Okay,
Again, your lordship will find type of enterprise medium,
hmm,
and this upgradation happened. If your lordship kindly turns the page to page 24, your lordship will find the date. It is 23/1/21.
okay,
Now, the relevant notifications are. Your lordship will come to page 27. This is the first notification. This is of 26th of June 2020. And the relevant clause is at page 29. Clause A,
hmm,
updation of information and transition period in classification.
hmm,
And subclause 5 thereof is the relevant clause. In case of an upward change in terms of investment in plant and machinery or equipment, or turnover or both, the consequent reclassification. An enterprise will maintain its prevailing status till expiry of 1 year from the close of the year of registration. So initially it was 1 year by virtue of this notification. Then this notification itself underwent an amendment, which you also will find at page 30. This particular clause, subclause 5 of clause 8, stood amended by virtue of this notification. And your lordship will find the amended portion, the subclause 5 of clause 8. In case of an upward change in terms, rest of the language is exactly the same. Instead of 1 year, it says 3 years. As my lord got it.
hmm,
Now, in terms of this, now when the respondents issued the NIT, which you will find at page 31, they have incorporated these clauses. They acknowledge the existence of this statutory mandate. The NIT starts at page 31. And the relevant clause, your lordship will find at page 81.
hmm. Yes,
Clause 16.9. MSCs, micro and small enterprises, are exempted from submission of EMD in accordance with the provisions of so and so and clause 40 of ITB. Now, this clause 40 of ITB, your lordship will find at page 92.
yes,
Clause 40 is right at the middle. Relevant is clause 40.2. In case bidder is micro or small enterprise, the bidder shall submit Udyam certificate, registration certificate for availing benefit under the public procurement policy for so and so. White Gazette notification dated 18/10/22, which I referred to just now, of MNC. The following is notified. The same clause is reproduced right below that. And what it says is accordingly, in case of upward change in status, MSc bidder is required to submit the previous certificate also to get the MSc benefit.
that is a small one.
Small. So I am required to submit both the certificates, medium as well as small. Now, if your lordship kindly comes to my tender, which is, I have annexed the relevant portion. It is at page 125. And these two documents, these two certificates are at page 130 and 130. The exact same certificates that I placed, which are at page 22 and 23. Form part of the NIT at page 130 and 130.
Not very legible, but nevertheless,
Exactly the same documents as page 22 and 23.
all right. These are part of your
It's
documents
part of my tender.
submitted.
Submit. And now the impugned image is at page 133.
Valid EMD.
They say not qualified commercially due to absence of valid EMD, which is not a requirement because I am exempted, or EMD exempted documents as on with you.
You are exempted under clause
Clause
16.
clause
16.
16.9 rate with 40.2. $16.9 is at page 81.
What is your business otherwise?
Various kinds of construction work.
Okay. So you're rejected as not found to be technically viable.
Because I did not submit my EMD.
Okay, now,
Now, my instruction is that they have in the meantime opened the financial bills. And the specific instruction I have, although I have not made the statement because at that relevant point of time, I did not have the exact figures. Now I have the exact figures. I have made the statement that it is substantially, my bid is substantially lower. Now my instruction is that the difference is of 2 crores.
between whom? How many bidders?
There were several, almost about, we don't know the exact number, but there were quite a.
So how do you say your difference is 2? One
Because
is
he is the, he has been found to be the alpha. Just one number.
in the financial bid.
Fine. And my bid has not been opened at all because it has been rejected on technical grounds. So therefore, madam, at this stage, I am praying for an interim protection, madam, let them not issue the work order.
What is the tender for?
This is for madam, development of a site that your lordship will find at page 31.
Boundary wall,
Boundary wall and house
Site
site, etc.
civil work.
Civil work.
These documents submitted petition is a valid one or not, my lord?
Who are you?
Response number 2, my lord.
You are the employer.
Yes, yeah. But the tendering authority is, they have outsourced it to respond number 3.
I'm going to see my page on 25 minutes.
Hmm.
And when it was 9 my lord, it was a small my lord. And when it was converted to medium my lord, when it was converted, you will see page 25 my lord. This is document my lord. Because this is not a certificate my lord, which shows that my page 25 my lord, can you see my lord?
Yes.
Investment in plant and machinery or equipment in rupees. Second, my lord, 1920 medium.
Now, which part are you reading?
Page 25, my lord.
Yes, 25 is a registration.
Yes, my lord.
Certificate.
Now it is mandatory. That's what I am saying.
So which column you are reading?
My investment in plant and machinery.
Investment in plant and machinery. Yes, yes.
Financial year, my lord,
Hmm.
1920 medium.
Hmm.
And to 1819 medium.
Hmm.
So it was converted from small to medium to 18 and 19. So he has already been elapsed, my lord.
Hmm.
So 3 years period has already been over, my lord.
Where is it mentioned 3 years?
My lord, for notification that I will see. Page 30 minutes.
Page 30.
This is the amendment of earlier.
Hmm. What does it say?
In case of upward change in terms of investment in plant and machinery or equipment or turnover or both, the consequent rate classification and enterprise shall continue to avail of all non-taxable benefit of the category micro, small or medium. It was in before the reclassification for a period of 3 years from the date of such upward change.
Meaning?
So it commences from 18 and 19, madam.
No, what is the meaning of this?
The exemption will cover, madam, for a period of 3 years from the date of conversion from small to medium.
I don't know, but I read it. Then in case of upward change means you are going up.
Yes, madam.
That means from small to medium.
Yes, madam.
In investment reclassification,
Yes,
that enterprise will continue to avail all non-tax benefits
it is my EMD.
of the category.
Yes, madam.
It was in before the reclassification,
Yes,
meaning if it was small and if you go for an upward change to medium, you will continue to get the non-tax benefits of small for 3 years. It doesn't say your benefit for upward classification of medium will go away.
No, man. In case of a reclassification,
Reclassification.
the petitioner reclassified.
You read the entire paragraph.
In case of upward change in terms of investment in plant and machinery or equipment or turnover of both and consequent reclassification and enterprise shall continue to avail of all non-tax benefit of the category micro, small, medium. It was in before the reclassification. For a period of 3 years from a date of such upward change. I will see page 22, in 2009 matter, which was a small matter. Page 22 mathematics.
What is the meaning of this? The enterprise shall continue to avail of the category. It was in before reclassification.
Like if he avails my lord, no, it's only benefit.
You read it again. You read it again. You read it from an enterprise shall continue. You read it from
Yes,
consequent reclassification.
Yes.
So first thing, it is upward change. Means you go from a lower category to a higher category.
Yeah, but it was before the reclassification, second comma is there, for a period of 3 years from date of such upward change. So from when matter it was converted matter, from small to medium.
Yes. What are you entitled from that date?
Yes,
For
madam.
3 years?
Yes, madam.
What benefit?
Normally, exemption, madam.
Exemption in which category?
From small to medium matter, when it was converted to medium matter.
You read it again. You read it again.
It was in before the reclassification.
No, you read the whole.
Yes, madam. In case of upward change in terms of investment in plant and machinery or equipment or turnover of both and consequence.
Now, wait for a minute. In case of upward change in terms of investment, what is the meaning of that? Upward change means you go from low to high.
Yes, madam.
That means from, if you're small, then you go, you become medium. If you're medium, you become large.
Yes.
All right?
Micro is not.
Yes. And consequent reclassification means once you go upward, your classification will have to change. You are small, now you become medium,
Yes, madam.
right?
Yes,
Enterprise will continue to avail of all so and so benefit of the category.
yes,
Of the category. It was in before the reclassification.
yes.
Which category benefit you get? Which category benefit?
Small.
Small. For how many, what is the period? For a period of
It
3
was
years?
before the reclassification.
For a period of 3 years. So notwithstanding you're reclassified as medium, your benefits as small, you'll get it for 3 years from the date of reclassification.
Yes.
Then,
Now, madam, the document shows much. It shows only the wisdom registration certificate. It doesn't show, madam, when it was reclassified. But from his account statement, madam, from turnover, madam.
from 1819, if he's medium, if he's medium, what you're saying is, are you saying that this benefit is only for small, not for medium?
For medium also.
So if it is for medium, then the medium is already a medium.
For 3 years only, madam.
No, from this, how will you get it? For 3 years. Mr. Chaudhary, is there a,
What he is getting confused with is, he is trying to show from page 25.
no, page 30.
Page 30, there is no dispute. What has fallen from your lordship is page 30.
So what has fallen from me is not accepted by them. That is what is making me
And
confused.
if they come up with any other interpretation, that is not even acceptable. What perhaps my learned friend is trying to indicate is from page 25 is, he is trying to say that since the NIT was in 2023, and if your lordship kindly sees page 25, he wants to say that I became medium from 2018-19. So therefore that 3 years has already elapsed, you won't get the benefit. That is perhaps what he is trying to say. But that is not the certificate. The certificate is the previous page. What thereon clause says, if
No,
your
but,
lordship come-
but is that the interpretation of page 30? The particular-
no, well, that is where they are
This is not a
totally
certificate, madam. This is the wisdom registration certificate, madam. They have not connected the certificate of
Is
conversion.
it your case that he's not a medium?
No, he is a medium, my lord.
He's medium.
Now.
Now, if he's a medium, is he not entitled to the benefit?
Up to 3 years, my lord, from the date of conversion, my lord.
From where you have stated there?
It was in before the reclassification.
I don't know, I'll have to learn English again. I have lost confidence in my ability to comprehend English. We'll have to appoint an amicus to give us proper understanding of this. This clause says your benefit in the category the industry was in before reclassification, because once there is an upward change, you are entitled to reclassification. So that enterprise will continue to avail of all non-tax benefits of the category. It was in before the reclassification for a period of 3 years from the date of such upward classification, meaning if you are in the small category and you get upward reclassification to medium, then from the date of reclassification for 3 years, the benefits of small, you can get the benefit.
That's what I am trying to make.
So where is the difficulty there?
So when 1819, it was converted, my lord.
Converted 1819. So 21, 22, it is expired. Is that what
Yes,
you
ma'am.
say?
Yes.
Is expired benefit of what? Small industry. His benefits of 3 years will expire in 1891 or what? Small industry, but he's a medium industry. A medium is not excluded. Had it been a case that he was a medium, small industry, and it was restricted only to small industry, then yes, you are correct. But he's a medium. You need to complete your instructions here.
Let them file an affidavit, everything will be clear.
Like,
the understanding of the authority.
no,
I can understand all of these.
Perhaps
without
bringing he get the benefit, my lord, up to 3 years, my lord, from 1819 to 21, my lord.
if there is any other clause, you show it to us, but this clause doesn't say so. We're sorry to disagree with you. This clause at page
This is
30,
the understanding of the tender committee also.
no, but you are a counsel, what is your understanding? Forget the tender committee as an officer of the court, what is your understanding of page 30? You tell us if the understanding is incorrect, somewhere we may have missed out 1 or 2 words, but
The last 2 words are from upward sales, my lord.
no, upward change is, you cannot read this in isolation.
Yes, sir.
You have to read it with the entire paragraph.
He said it was in before the reclassification.
You read the entire paragraph. Mr. Roy, you are supposed to be helping him, not, if I may use the word, not misinterpreting it.
understanding was also with my friend because he will get the benefit up to 3 years.
What benefit?
The exemption from EMD deposit.
In which category?
In small category, in medium, he reconverted to
No,
medium.
no. You read it with reference to this clause.
Lordship, that's why he looked.
He's entitled, if a person, if in the enterprise is small, he gets benefit.
Lordship.
If it's medium, he gets benefit.
For
Now-
now, 3 years only.
No, that we don't know.
Yes.
In terms of this, that 3 years benefit is given to that particular enterprise of those benefits in the earlier category.
Yes. This
For 3
benefit
years.
Will come.
So you can say his claim for benefit as a small enterprise after reclassification as medium will expire after 3 years. We agree with you.
Yes.
But medium is also given the benefit of exemption.
No, lordship, only 3 years, for 3 years. only.
Huh?
Yes, ma'am.
Clause number, what is that? Clause number 16,
40, lordship.
40.
Lordship, page 19.
Is it small or only medium also? Who are exempted?
Micro and small,
So you are what?
medium. I have medium, undergone an upward medium.
To medium, you are excluded now.
Otherwise, I am excluded. But by virtue of that clause,
The clause is for 3 years.
3 years. That is where is the confusion. Let me point out, Madam. If your lordship will kindly come back to page,
Yeah, let us see clause 40 first, 40.
page 92, page 90.
What does it say?
What your lordship will first read the whole portion, Madam.
Hmm.
In case bidder is a micro or small enterprise, the bidder shall submit Udyam registration certificate
Hmm.
for availing benefit under public procurement policy for MES so and so. By notification, that notification, amendment notification is reproduced
Hmm.
and thereafter.
Hmm.
Accordingly, in case of upward change in status, MSC bidder is required to submit the previous certificate also to get the MSC benefit. Now I have become a medium from small, so I am required to submit both my medium and small.
No, medium to small or small to medium.
Small to medium. Now, what has perhaps created the confusion is this. The Udyam registration certificate is at page 23. So what I am required to submit is the Udyam registration certificate,
Page 23.
page 23. If your lordship kindly turns the page, the date of this Udyam registration certificate is 23/1/2021. Page 24. Your lordship will find the date.
23/1/2021.
Yes, so I will continue to get the benefit for a period of 3 years from this date, which will expire on 22/1/2024.
But
Now-
they are referring to a document where it says 1890.
Change to page 25. But it says from the date of the registration. Reclassification. Now, my upward movement might have started. My upward movement might have started in 2018-19, 1920, but the registration certificate is of 21. So the language employed is from the date of the reclassification. This reclassification happened on 21st of January 2021. I might have moved upwards, but the reclassification happened on.
The reclassification may have happened in 1890. This certificate may have been issued later.
No, yes, it is a reclassification unless. My lord, just to,
Where is the certificate again?
this, page 23 is the certificate.
23 is the certificate.
This very clearly says
Udyam
Udyam registration certificate. And the date of the. Your lordship will kindly see the date,
Is
date
there
of Udyam registration, 23/1/21.
Is there a process? It must be a process of evaluating your updates.
Perhaps they might have taken time to issue the certificate. That cannot be attributed to me.
No, that perhaps it cannot remain as perhaps, it has to be definitive. Either they have taken time or you have taken time. Delayed.
We could not have. The ultimate reclassification happened on 23rd of January 21.
And whose document is at page 25?
This is, this forms part of the, part of page 22. Otherwise, had I had to play any hide and seek, I would have very conveniently.
MSME app from you.
My lord will kindly come to page 20.
This is the Udyam registration certificate.
What is the meaning of that?
It is mandatory, on 20 minutes. To register Udyam hotel, madam. So it was converted, my lord, in 1819, my lord. It was updated, my lord, from small to medium, my lord.
No. You say with them registration is necessary. So with them registration necessary will be effective from the date of the certificate being issued. Who issues the?
This is only registration in Udyam, it's a hotel, my lord. But when it was converted, my lord, it's not.
Who issues the conversion certificate or order? How do you convert it?
Just to give an example, my lord. If I masquerade around as an advocate, until I get a license, will I be called an advocate? I have to get the
license issued by the bar council. I might wear whatever fancy black and white dress and masquerade around as an advocate, but till I get the license, I am not an advocate. The same analogy applies here. In fact, page 26,
That's why the word reclassification was used, madam.
your lordship will kindly come to page 21.
What is the process of reclassification?
Section 7, madam, there is a turnover, madam. From 5 crore to up to 10 crore, it is medium.
Who decides that? There is a committee.
It's a ministry of madam micro, small, medium enterprise. There is section 7, madam, to give them a turnover, madam. From 5 crore to 10 crore, it is medium, madam. If the transfer is get updated, madam, immediately, madam, is it will be sales, madam. And secondly, in this case, madam, the petition has been filed by one of the director, madam, but not supported by any board resolution. That is mandatory, madam, as per the company said, madam, because the petitioner is a company limited, madam, private limited company. The affidavit has been filed by one of the director, madam. He was not authorized by any of the.
It's not a defect, it cannot be cured.
That we have stated consequences that are undealable. If it's necessary, we can produce the.
Yeah, you produce it, and there's an objection raised.
In one of the other caption from my if one of the board the board resolution is mandatory.
It's a
Because
specific.
the and that is filed one madam has Agoda, madam, and this petition has been filed one madam Lolita Agoda.
This registration certificate has come under what provision?
Under this notification,
Page number
page 27.
27.
Clause 8 itself says how the transition will happen, and the responsibility is cast from the authority to communicate. If you want to come to clause 8, I had pointed out clause 5, the entire process of updation. Clause 4 is important. In case of graduation from a lower to a higher category or reverse graduation, sliding down to lower category of an enterprise, a communication will be sent to the enterprise about the change in the fund. So the responsibility is cast from the authorities to send the. But now, when I have updated it, they could not have got this information without me updating it. I have updated it, and they deemed it appropriate to issue the reclassification registration on 24th of January 2021. How can that burden be shifted to me? If your lordship will kindly have
Yes,
page 25, what my learned friend was pointing out, it is page 26, which is a continuation of page 25. Even down below, your lordship will kindly see. Right at the bottom, your lordship will see the date of ODM registry. Even that document also says 23/1/21.
so date of reclassification is relevant here.
Yes.
So what is the date of reclassification?
But as per this, 1819, madam,
This is the year, what is the date?
18 number submit, madam.
If it is there in the portal,
Because
if it is there in the portal, you should get it. You can't reject a tender on the ground that it must be in some date.
I cannot, madam, because
You know why you cannot? You are insisting on registration, it is available in the portal.
but as per the document itself, madam, it is on 1819, madam.
No, but where have you stated that the registration is not the date of the relevant date for updation? You must bring it to his notice. You have rejected him
Yes, madam.
by holding that it is not 21, but it is 18,
Yes,
1819. But there must be a reason for that. You have to say that, no, this certificate is not acceptable. It does not satisfy, this certificate does not reflect the date of reclassification.
To my understanding, madam, now, madam, it is not required, madam, to give the reason, madam, as per after
Farming order, working order, safety must have to, is a administrative process, my lord. There's no way to
Oh,
give any-
administrative process, if it is there, you don't have to give, then we might as well, next submission would be, the court should not interfere with any contract matters. Why come to court at all?
Until unless there is some malafidness.
So how do we judge whether the mala fide is there or not unless you come out?
Converted in the.
How do we know that you don't have mala fide? He's come before the court alleging mala fide. You justify that there is no mala fide.
But that's why I'm showing my page 25, my lord.
Page 25 is not acceptable. Page 25 says it is the date.
1890, my.
Page 25 also, where is that date?
It is the
Page 26.
It is not to bring those documents.
Date of ODM
He has
registration.
already brought a 23/1/2021. You have to now say,
But this is a registration matter. But the documents, whole documents shows them it was converted in 1890.
you are not answering to the queries, you see. You have to have a date
Yes,
from which he ceases to be small and becomes medium. What is that date? Who gives that date?
but the go matter, it was decided to 21 matter. But if Indian projects matter, shows that matter, it was converted in the
On
1890.
what basis are you saying that?
Why it is, bro? In basement of.
Your interpretation of 2018-19 being the date of reclassification is based on what?
It is in the EMR, financial year, matter.
On what basis? Notification, office of memorandum, act, rules, what? You give us an interpretation with regard to these.
Kindly say, matter. There is matter 20 matter, 22 matter.
What is the purpose of ODM registration?
Now matter it is mandatory, but.
Mandatory for what
Data
purpose?
benefit matter.
Huh?
To data benefit matter.
To get the benefits.
What benefit?
For not submitting this money like that.
So if you say that someone is got a ODM registration in 23, but you have been classified or reclassified 5 years back, under what authority do you disown him from the benefit? When the ODM registration says it is necessary to register to get the benefit.
Kindly say, please.
22.
matter.
Yes.
Date of commencement. 1/10/2009. Major activity manufacturing. Enterprise can be small. It is also minor. Acknowledgement in bottom matter. Date of filing 1/5/2017. Then matter in page 25. And to see matter. Now it is 1819 become medium matter.
No, I have understood whatever you submitted. What I want to know is this office memorandum at page 30 giving the benefit for 3 years.
Yes.
It is 3 years.
Yes.
From the date of such upward change, what is the date? Where is the date?
We have to see.
What is the date?
That UP customer petition.
No, please tell me one thing. This is the statute. It defines small, micro, medium, etc. If everything is cast on the petitioner, then the petitioner can tomorrow say, sorry, I am not medium, I am small.
Come on, the documents itself shows my.
No, supposing he says, oh, these were printing mistakes, we are supplying you new documents, this is small. Will you accept it? Will you accept it? Why not?
Then we have to, contact the ministry.
So you contact it. Well,
Because
without-
permit is my lord.
what prima facie?
But it was.
Prima facie, you are insisting on this clause. You're insisting on this clause, the 3 years benefit,
Yes, sir.
without getting the confirmation that what is the date of upward, what is the date of reclassification. For a period of 3 years from the date of such upward change, what is the date of upward change?
Another thing will perhaps make it clear, if you not will kindly come to page 22.
Mr. Counsel, the difference between an administrative and a judicial proceeding is, in an administration, you are not required to answer, you are the boss, you do whatever you want. Such things don't happen in a judicial forum. And you are a counsel appearing before the court. So somebody in the administration says, this is what we do. Your judicial mind must be activated to understand on what basis. Because you are appearing before the court, not them. You clarify on this particular clause. This is the clause you are relying on. This clause is categorically said from the date of upward change. Who decides on that date? There must be some authority who says that this is the date from which you will be counted as small, this is the date from which you will be counted as medium or micro. What is the stage of the contract now?
Acts of acceptance has been issued to madam. Acts of acceptance has been issued, madam. One by the Sarkar Construction Private Limited. But the LOI is issued.
Yes, Mr. Chaudhary.
We have hired him as a restaurant number 4, sir. We came to know to them that he has been found to be the L1 because my tender has not been opened. Financial risk. And work order has not been issued. That is the statement we have made, sir.
When can you get the clarification?
Monday, madam. I think.
Monday. All right.
Let it be on Wednesday. Monday I am in Itanagar for a constitution.
On Friday, madam.
This Friday. Day after tomorrow I am.
Friday. Okay. Get it on Friday then. I'd learned Mr. I. Chaudhary, learned senior counsel, assisted by Mr. N. Mr. Verma and Mr. S. Botaku for respondent number 2. Yes, Mr. Roy for 1. 3 and 4. Notice has to go. Should we issue notice or we wait till Friday?
Let them get the.
Yes. The issue involved in the writ petition is the rejection of the petitioner. Petitioner's bid in response, a bid which is submitted in response to the NIT invited by the respondent number 2 for page 31, balance boundary wall, etc. So and so work. Stop. The counsel for the petitioner, senior counsel for the petitioner submits that the petitioner enterprise was initially registered as a small enterprise under the MSME Development Act 2006. Subsequently, the petitioner was reclassified as medium industry and the date of Udyam registration was shown as 23/1/2021. Stop. Learned senior counsel submits that as per clause 16.9. The petitioner was exempted. Page number 40.
92 clause 40.
90. No. 16.9.
That is
81.
81.
As per clause 16.9, MSMEs enterprises were exempted from submission of EMT in accordance with the provisions of PPP 2012 and clause 40 of the ITB. Stop. Clause 40 of the ITB also lays down the public procurement policy for micro and small industries. And the following benefits and the following benefits are available in case of works contract also, namely issue of tender document to MSEs free of cost. Number 2, exemption to MSEs from payment of EMD bid security. Stop. Learned Senior Counsel submits that the petitioner submitted its bid along with all relevant documents, including the exemptions for which it is eligible as under the benefits given to the MSME registered enterprises. However, on 17 July 2023, the petitioner was served with an email from the tendering authorities whereby it was informed that page number 133, portfolio not qualified commercially due to so and so within quotes and italics. Stop. Page number 133. Para being agreed, the present petitioner is before this court. It is submitted by the Learned Senior Counsel that in the meantime, the tendering authority has proceeded to open the financial bid, and as per the information available, the respondent number 4 has been shortlisted as the L1 bidder. Stop. It is, however, submitted by the Learned Senior Counsel that no work order has yet been issued as on date. Stop. It is submitted that the petition, as per information from reliable sources, information available, the bid submitted by the petitioner is about 2 crores. 2 crores higher. Lower.
Petitioner's bid is lower.
2 crores lower than the bid submitted by the as so-called L1 bidder, namely respondent number 4. Learned Counsel for the petitioner submits that this rejection of the petitioner's bid is totally contrary to the clauses of the NIT as well as to the provisions of the MSME Development Act and the government notifications and OMs issued from time to time. Mr. S. Bhattakur, Learned Counsel appearing for the respondent number 2, strenuously objected to the submissions made by the Learned Senior Counsel. He submits that in terms of the notification number dated 18th of October 2022, the benefits of a small or a micro in the enterprise will be available to the said enterprise, notwithstanding its reclassification into a higher category, namely a medium enterprise, for a period, only for a period of 3 years from the date of such upward change. Stop. Mr. Bhattakur, referring to the documents, referring to the registration certificate, ODM registration certificate issued by the Ministry of Micro, Small and Medium Enterprises, which was submitted by the petitioner, referring to the said certificate submits that in the said certificate itself for the year 2018-19 and 2019-20, the enterprise type was shown as medium within quotes. Stop. Accordingly, the submission by the Learned Senior Counsel for the petitioner that the present petitioner's benefit of a small industry, small enterprise will be available for 3 years with effect from the date of registration, which is 23/1/2021, cannot be accepted. Stop. He submits that the industry was classified as medium with effect from 2018-19 as per the documents submitted by the industry itself. Stop. In that view of the matter, the interpretation sought to be given by the Learned Senior Counsel that the benefits of a small industry would be available to the industry notwithstanding its reclassification as medium for 3 years had expired since it has become medium with effect from 2018-19 onwards. Under such circumstances, the benefits available to small and micro industries cannot be available by the petitioner, as it is now reclassified as medium industry with effect from 2018-19. So, having heard learned counsels for the parties, it is seen that the notification dated 18th October 2022, whereby subpara 5 or para 8 was substituted with the following. Page 30. Subpara 5 is extracted. So, perusal of the same reveals that the benefit of a micro or a small enterprise will accrue to any enterprise, notwithstanding its reclassification pursuant to upward change in terms of investment in plant and machinery or equipment or turnover or both, for a period of 3 years is from the date of such upward change. Stop. While the learned counsel for the petitioner submits that the date for reclassification pursuant to upward change has to be accepted as a date of medium registration, which is 23/1/2021, and in which case the petitioner will be entitled to the benefits of a small enterprise. The learned counsel for the respondent disputes the same interpretation and submits that since the petitioner has been classified as medium for the financial year 2018-19, the benefits that will accrue to the petitioner as a medium enterprise pursuant to reclassification will be available from 3 years with effect from 2018-19, and therefore the same got expired in the year 2021-22. And as such, the petitioner is not entitled to the benefits as shown to be available to micro, small and medium enterprises under the NIT. Stop. The question which arises before this court is the date of reclassification. Is the date of reclassification to be the date of medium registration, or is it the date on which the petitioner on which the enterprise is shown to be a medium enterprise? Stop. There are learned counsel for the tendering authority, respondent number 2, Mr. S. Bothakur, submits that he will obtain specific instructions thereon and place it before the court on Friday, which is 4th. Stop. The learned counsels are in agreement that the matter can be taken up again on Friday, and on which date further orders, as necessary, may be passed. The learned counsel for the respondent tendering authority submits as the question of maintainability be left open to be decided. Stop. Considering the fact that the tendering authority has already open the financial bid and considered the respondent number 4 as the L1 bidder till Friday. No work order be issued with the court. till Friday.
Yes, Mayor.
We don't know, or we can record your statement, whichever is convenient. We may record your statement, but it is better to pass a judicial order.
Yes, nothing happened.
Why are you risking your? Till Friday, we are giving it, why do you undertake that nothing will happen? You are not in charge of the tendering authority. You are representing them. We have recorded your submissions.
Because it's time.
Huh?
Because it's time and.
No, trying is what you need to do, but what I'm saying is, you as a counsel will represent your client on the basis of the instructions. You do not know as on date what steps they have taken. Why are you volunteering to give an undertaking that nothing will happen? It is in your interest that we are passing an order on Friday, till Friday.
Right.
You'll furnish extra copies by today itself.
I'm being item number 57.
Yes, 57, who's there? Mr. Gogoi. Your colleague, Mr. Chaudhary, assured that he'll be here, but he's not here. This, I'm told, some order has been passed, the appellate court interfering with the order of the single judge. Are you aware? Can you find out and inform the court tomorrow? Tomorrow?
Yes.
Or day after?
Friday.
So we just need to know what orders have been passed. If it has been interfered with, then interfered with.
Otherwise, the content will.
On 31/7/2023, Mr. D. Chaudhary was requested to intimate
He's coming.
the court. He's coming, where is he? Holy God. Yes, Mr. Chaudhary,
Yes, ma'am.
what is the instruction?
Also, subsequently, what under proceeding has been concluded, he has imposed the punishment of compulsory return.
No, you mentioned that there is some division bench order, it was interfered.
Lordship, in the retake, the state went on retake, and there the punishment order was also taken.
Huh?
And taking carrying, lordship was
Oh. What was the direction here?
Lordship, to complete the departmental proceeding within.
Okay. None appears for the petitioner on call, Mr. D. Chaudhary, learned counsel for the appears for the respondent. They'll stop this contempt petition. Has been filed by the petitioner alleging willful disobedience of the order dated 13/3/2019, passed in WPC 1604. Stop. By the said order, the following directions were passed. Right from extract from para 2 onwards. It is the contempt petition was filed that in spite of representations being issued, the directions of the Learned Single Judge has not been complied with. Here are Mr. D. Chaudhary, Learned Counsel, appearing for the respondent, submits that being agreed by the said order, a writ appeal was preferred, being writ appeal number 58 of 2020. Whereby whereby it was revealed during the course of the hearing before the division bench that pursuant to the orders passed by the London Single Judge, the inquiry was completed and the departmental authorities disciplinary authority had accepted the inquiry, the findings of the inquiry officer, and had thereupon proceeded to compulsorily retire the petitioner by imposing penalty under Rule 7 of the Assam Services within bracket Discipline and Appeal bracket Rules 1964. Stop the said order. Yeah, stop. The said order has been endorsed by the Assam Public Service Commission. Full stop. In view of the order passed by the disciplinary authority, the writ appeal was accordingly disposed of. Stop. Thereof, considering the directions passed in writ appeal number 58 of 2020. 1. No further order needs to be passed in the present contempt petition. A copy of the order dated so and so 14/10/2020 passed in writ appeal 58 of 2020 by the division bench has been furnished before this court by the learned counsel appearing for the respondents. In view of such orders being passed by the division bench, the directions contained in the order dated so and so 13/3/2019 passed in the WPC 1604 of 2019 has been found to be complied with. The contempt petition accordingly stands closed. Notices issued are reported. Contempt petition disposed of.
For hearing item number 54.
This hardly anything is already rejected. What is there? What is there? His application, his proposal has been rejected. Now you have to, if you want, you file some other petition. Nothing left to be done here.
Can it be taken up tomorrow now?
Friday.
Yes, right.
Item number 55.
This case relating to Pokemon and this bill regarding university. We are in the case. Petitioner was joined on 29/10/19 executed as LBA system in the office of the sub-regional Richard Development of Pata. Number 5 joined on 9/9 executed. In the district Vishari officer NCS Saplo.
Before that, most probably this matter has become infracture. This petition was filed in the year 2017. And then from the affidavit, it reflects that the petitioner says it's 59. And the petitioner is challenging the contemplating promotion of the respondent number so and so. So whether a direction can be granted for granting promotion to the petition.
National benefit.
National benefit is to file another application.
Was entitled at that point of time.
No, if in case of any
National
notional,
entitled.
in case of any.
I retired.
Have you completed? In case of any notional benefit, he has to file another application. At that time, she was in service in 2017. And without there, how a promotion can be granted. Without there being a DPC, no promotion. Considered also. So most probably at this stage, this petition has become impactful.
Upon my submission is there and understand is there not in further because I approached this honorable court prior to retire. And I retired from service on 31/3/2018. And this petition was filed in 2017 on
Yes, at that time, this petition,
due to business of the court lordship.
All right, we'll hear it on Saturday. Who's for the respondent number 5? Yes, what has happened?
My lord, my lord, the respondent number 7 is all along CBO to the.
7 or 5? 5.
Respondent number. If lordship may kindly come to my lord, the gradation list, which they have calendar.
Rule is that district by
You also support.
Is there a service rule?
service, there is not service, but guidelines for.
What guidelines?
Of this on post direction.
Where is that direction?
That guidelines also will find.
Page 14.
Taking order is page 23. Page 23.
Where is the order of the High Court?
That order, I have not annexed lordship.
You get it? Get all the orders. We'll take it up on Saturday.
On Monday,
Saturday,
my some difficulty.
no difficulty. Saturday.
I said,
uh,
on Monday, lordship, some difficulty on Friday.
Friday,
Friday after 2 days. Already been faced.
we have 50 cases.
Oh, yes.
Huh? Friday? Saturday, no.
That's another.
You get the copies of the order then. We'll try to take it up on 10th August. 10th August. At the request of Mr. F.U. for we and Learned Counsel for the petitioner, matters 10 adjourned to 10, enabling him to place before the court the orders of passed by this court, which are sought to be relied upon by the petitioner and which are not available in the paper book. Mr. Reid Sharma appears for the respondent, Mr. C.S. Adarika for your appearing. No. Mr. Dr. For respondent 5. List on 10. Right. Part 2. No part 2.